We're live on Capitol Hill this morning as the Inspectors General of Military Service Branches will be speaking for a House Armed Services Subcommittee on procedures for investigating misconduct of senior military leaders. This hearing expected to get underway in just a moment. Live coverage here on C-SPAN 3.
This subcommittee hearing is called to order. I want to welcome everyone to this morning's Military Personnel Subcommittee hearing. The purpose of today's hearing is to receive testimony from the Department of Defense and the services regarding efforts they have taken to investigate and hold senior leaders accountable for misconduct, and to understand what programs and policies are in place to prevent misconduct. Our military enjoys the highest confidence rating by far of any institution in American society. This well-deserved reputation has been earned through the service and sacrifice of millions of brave men and women. One byproduct of this reputation is that the military and its leaders are held to a much higher standard than almost any other institution, and I know that you wouldn't have it any other way. Consequently, the misconduct of a few can greatly impact the military's hard-earned reputation. When the misconduct involves flag or general officers, the negative effects are even greater. These incidents of senior leader misconduct, even though relatively rare, not only hurt the victims involved, but can have a lasting impact on the readiness of the unit in which the senior leader has served. While one incident of senior leader misconduct is too many, it is important to acknowledge that the vast majority of senior leaders serve with distinction. It is also important to acknowledge that some of the acts of misconduct that the military investigates and punishes would not be investigated, much less punished, in the civilian world. Nonetheless, military leadership must continue to ensure that all senior leaders uphold the highest standards of ethical conduct, and when senior leaders fall short, they must be held appropriately accountable. We will hear from two panels today. The first panel consists of the Department of Defense and Services Inspectors General. They will discuss the reporting and investigation of senior leader misconduct in addition to the types of cases they investigate. For the second panel, we are honored to have the Vice Chiefs of the Army, Navy, and Air Force, along with the Assistant Commandant of the Marine Corps. They will discuss what happens to those IG investigations if they are substantiated, how they hold individuals accountable, and they will provide an overview of their prevention programs. I look forward to hearing from our witnesses today about ethics and mentorship programs in place to prevent misconduct. I am also interested to hear how the services investigate misconduct allegations and hold wrongdoers accountable. Additionally, I would like to know what trends had developed with regard to the types of issues that are being reported and investigated. Finally, I look forward to hearing what additional actions can be taken to further reduce incidents of senior leader misconduct. I would like to make two other administrative points. First, it is important to note that the Department of Defense's common definition of senior official includes an officer in the grade of 07 and above, including officers who have been selected for promotion to 07, or a civilian member of the senior executive service. For the purposes of today's hearing, and consistent with the jurisdiction of this subcommittee, the witnesses have been asked to focus on misconduct by senior military officers in the rank of 07 select and above. I would also like to remind the members that the witnesses today may not be able to answer certain questions regarding specific cases if the answer would compromise an ongoing investigation or would give rise to an accusation that the military has prejudged the outcome of a pending investigation. Before I introduce our first panel, let me offer the ranking member, Ms. Speier, an opportunity to make her opening remarks. Ms. Speier.
Thank you, Mr. Chairman. Thank you all for being here today, excuse me, and for your service to our country. You know, one of the core tenets of the armed services and of our country is that no one is above the law. From the most recent recruit to the most senior officer, all service members are subject to the same UCMJ laws and the same ethical code of conduct. But there is a phrase in the military that goes like this: different spanks for different ranks. And as Don Christensen, the former General Counsel for the Air Force, said, and I quote, an everyday troop is court-martialed for what a general officer is given a slap on the wrist. So it's with great sorrow and anger that I have read countless reports of misconduct among senior leaders, including general officers and admirals. This is borne out by the data. Buried on page 66 of an 85-page DoD Inspector General report on, quote, top DoD management challenges, unquote, is a finding of a 13% increase in complaints alleging misconduct by senior officials from fiscal year 2015 to fiscal year 2017, from 710 to 803. An increase in substantiated rate increased from 26% to 37%. The most common allegations involved personal misconduct, including improper relationships, improper personnel actions, misuse of governmental resources, and travel violations. In my time on this committee, I've heard over and over of the importance of the chain of command and how it leads to better justice outcomes. But many senior leaders who should be the essential core of the chain of command are not being held to the same standard as the rank and file. This corrupts fairness, justice, and morale. To illustrate the severity of this problem, I want to highlight 5 cases of senior leader misconduct from just the last few years. As you will see, these senior leaders committed serious crimes and rule violations, yet received only light, administrative, not judicial punishments. Most got no public scrutiny until journalists inquired about their cases. Army Major General John Custer had an inappropriate relationship with a woman, had his staff buy her sexy clothes, and lied to investigators about it. Lucky for him, General Martin Dempsey, then Custer's commander, removed, and I'm underscoring this, removed the substantiated account of an inappropriate relationship from Custer's record. How do you do that? So the review board could only consider lesser charges. Custer retired at a rank and kept his pension. So he retired at rank and kept his pension. The public only knows about this incident because a whistleblower told USA Today. Second, Air Force General Arthur Lichty was alleged to have coerced sex from a subordinate in 2007 and 2009. His victim believed she had to reciprocate the general's advances due to his rank and position. Lichty was reprimanded and demoted to Major General, but not for command rape, but for a, quote, inappropriate sexual relationship. Army Major General Ralph Baker assaulted a woman at an off-base event. For this, he received a letter of reprimand and retired as a brigadier general. The public learned about this 9 months after it happened following a FOIA request. Army Major General David Haight's exploits earned him the nickname Swinging General. He had an 11-year affair and regularly swapped sexual partners, which made him a foreign intelligence threat and target. As punishment, Haight was reprimanded and retired as a lieutenant colonel. But make no mistake, not all misconduct is sexual. At West Point, the man in charge of teaching future leaders ethics, Superintendent Lieutenant General David Huntoon, Jr., made his staff work at private charity dinners, give free driving lessons, and feed a friend's cat. Huntoon received a reprimand and retired at rank. The IG report was kept secret for more than a year and only released via FOIA as Huntoon neared retirement. Colleagues, these are just 5 stories out of an estimated 500 since 2013. They don't even include criminal misconduct of the type we've seen in the Fat Leonard case, in which 330 Navy personnel, including 60 current and retired admirals, are under investigation for accepting bribes and gifts. And these aren't just ordinary bribes and gifts. Some of them included a $18,000 dinner or a $50,000 stay in a swank hotel. Sometimes these bribes and gifts were exchanged for revealing classified information. But I picked them because they are illustrative of a deep and systematic problem in the armed services. Leaders set the standard, and when that leadership is toxic, it drips down to all levels of the military. Based on the DoD Inspector General's own data, it is clear that the current system of deterrence is not working. In today's hearing, I want to hear from all our panelists about what they are doing to exert sufficient oversight. In the case of the Inspector General, how are they working to increase accountability and transparency? In the case of the vice chiefs, what are they doing to combat criminal behavior and corruption? Thank you, Mr. Chairman, and I look forward to hearing from our witnesses.
I thank the ranking member. We will give each witness the opportunity to present his or her testimony, and each member an opportunity to question the witnesses for 5 minutes. We would also respectfully remind the witnesses to summarize to the greatest extent possible the high points of your written testimony in 5 minutes or less. Your written comments and statements will be made part of the hearing record. Let me welcome our first panel, Mr. Glenn A. Fine, Principal Deputy Inspector General, United States Department of Defense, Lieutenant General David E. Quantock, Inspector General of the United States Army, Vice Admiral Herman Shalansky, Naval Inspector General, Lieutenant General Stacey D. Harris, Inspector General of the Air Force, Brigadier General David A. Odignon, Inspector General of the Marine Corps. With that, Mr. Fine, you are recognized for your opening statement.
Chairman Kaufman, Ranking Member Speer, members of the subcommittee, thank you for inviting me to testify about the work of the Department of Defense Office of Inspector General regarding senior official misconduct, prevention, and accountability. In my written statement, I describe how the DoD OIG investigates allegations of senior official misconduct and oversees military service IG investigations of these allegations. In addition, I provide statistics and trends on the number of misconduct complaints, the types of misconduct, the number of investigations, the timeliness of investigations, and substantiation rates for both the DoD OIG and the service IG investigations. I also provide additional statistics for a particular type of misconduct, allegations of retaliation and reprisal by senior officials against whistleblowers. In my oral testimony, I would like to highlight a few key points from that statement. First, I believe it is important to recognize that the vast majority of senior officials in the DoD perform their challenging jobs with dedication and integrity. My experience, both as the IG of the Justice Department overseeing the DOJ and the FBI for 11 years, and from my experience for over 2 years performing the duties of the DoD Inspector General, is that only a very small percentage of these senior officials fail to uphold the high ideals and ethics required of their critical positions. However, some do commit misconduct. When they do, they need to be held accountable. The DoD OIG and the service IGs therefore seek to investigate allegations of misconduct in a thorough, fair, professional, and timely way. Second, the data I present in my written statement show that there was a significant increase in the number of complaints alleging misconduct by senior DoD officials from FY 2008 to FY 2012, and since then the number of these complaints has been steady. During the same period, the number of allegations warranting investigation by the DoD OIG or service and component IGs has decreased. Overall, the number of senior official cases with any findings of substantiated misconduct rose between FY 2008 and 2012 from 40 to 85, but has declined since then to 49 in FY 2017. However, I want to make clear our recognition that any misconduct by a senior official is unacceptable. Third, While the types of substantiated allegations against senior officials involve a broad range of misconduct, the allegations primarily fell within 5 main categories, which I describe in my written statement. Within these categories, there are several areas of particular concern. For example, there are a number of substantiated allegations against senior officials engaged in inappropriate relationships, and these cases have received substantial public attention. Fourth, the DoD OIG also has a criminal investigative arm, the Defense Criminal Investigative Service, DCIS, to handle investigations of criminal allegations. Currently, the biggest case DCIS is handling involves Glenn Defense Marine Asia and its owner, Leonard Francis, widely known as the Fat Leonard case. GDMA provided husbanding services to U.S. Navy ships in the Pacific, such as refueling and resupply. Francis orchestrated a scheme to defraud the U.S. Navy of tens of millions of dollars by routinely overbilling for goods and services. Francis accomplished this criminal conduct by systematically grooming and bribing active-duty military and civilian employees of the U.S. Navy with things of value, such as dinners, gifts, hotel expenses, money, and the services of prostitutes. To date, Francis and 17 former Navy and DoD officials, including a Rear Admiral and an SES member, have pled guilty to criminal conduct. In addition, in 2017, 9 senior officials previously assigned to the Navy's 7th Fleet were indicted for conspiracy, bribery, and false statements. That case is ongoing. Finally, my written statement discusses measures the DoD OIG has implemented to further improve investigations of misconduct. For example, to standardize investigations across the DoD and to speed the review process, we are working to implement a standardized case management database among the DoD OIG and military service IGs. To ensure compliance with laws and regulations and to share best practices among the service IGs, we have begun conducting quality assessment reviews of the service IGs, similar to peer reviews. To promote fairness, the DoD OIG provides subjects an opportunity to comment on the accuracy of our substantiated findings through the tentative conclusions letter process prior to completion of our final report. To promote transparency, the DoD OIG considers proactive public release of our completed substantiated reports, particularly those with findings of substantiated misconduct involving high-level officials. To help address timeliness, we have also reallocated resources within the DoD OIG to increase the number of investigators working on misconduct and whistleblower cases. However, handling the increasing number and complexity of complaints requires resources not only for the DoD OIG, but also for the service and component IGs. It is critical to adequately resource the DoD OIG as well as the service and component IGs, particularly when the DoD continues to grow. In conclusion, the DoD OIG and the service IGs have a challenging but critically important mission to investigate allegations of misconduct thoroughly, fairly, professionally, and timely, and we will continue to seek to fulfill that important responsibility. That concludes my statement, and I would be glad to answer any questions.
Thank you, Mr. Fine. Lieutenant General Quantock.
Thank you, sir. Chairman Kaufman, Ranking Member Speer, and distinguished guests of the committee, thank you for the opportunity to testify on senior leader misconduct. On behalf of the Secretary of the Army, the Honorable Dr. Mark Esper, and our Chief of Staff, General Mark Milley, thank you for your support of our soldiers, Army civilians, families, and veterans. The Army holds its senior leaders to the highest standards. The trust and confidence of the American people, which is intrinsic to who we are as an Army, is rooted in our character and our credibility. We do acknowledge problems exist, and we take senior misconduct very seriously. Over the past decade, the Army Inspector General Agency substantiated allegations against only 3% of the general officer population per year. While recent headlines on Army senior misconduct give the appearance of widespread misbehavior, the truth is most transgressions are technical violations committed by a very small minority. The most common substantiated allegations involving general officers are misuse of government resources, failure to follow regulations, and failure to take action. Substantiated allegations for inappropriate relationships or sexual misconduct over the past decade involved less than 1% of general officers. This small fraction of senior leaders does not represent the honorable service and character of the entire general officer corps. Whistleblower reprisal remains the #1 allegation. The substantiation rate for whistleblower reprisal cases is 4%. A significant factor in the low 4% substantiation rate is the misuse of the whistleblower reprisal process. This typically occurs when a soldier or a civilian is held accountable by a senior official for misconduct or poor performance. Following a protected communication, the resulting claim of reprisal creates challenges for senior commanders who hold people accountable and then are faced with an Inspector General whistleblower reprisal investigations. And in the last 3 years, whistleblower reprisal has basically had a 6-fold increase and is out of control in my view. The vast majority of the 685 general officers serving are doing the right thing every single day. The positive trend over the past 5 years has been a 51% reduction in the number of general officer substantiated cases from 32 in 2013 to 15 last year. This includes a decrease in substantial allegations for official travel violations, inappropriate political activities, non-federal entities involvement, conflicts of interest, and improper endorsements. In closing, the overwhelming majority of Army general officers abide by the letter and spirit of our laws and regulations and utilize sound judgment in the stewardship of taxpayer resources. Those who do not are held accountable. Mr. Chairman, members of the committee, thank you for your continued support of our soldiers, our civilians, families, and veterans. I look forward to your questions.
Thank you, General Quantock. For your testimony, Vice Admiral Shalansky, you are now recognized.
Chairman Kaufman, Ranking Member Speer, and Military Personnel Subcommittee members, thank you very much for having us here today to discuss senior leader misconduct and the opportunity to explain our senior leader investigative process. In the Navy, we take pride in living up to our core values of honor, courage, and commitment. We expect the highest ethical and moral behaviors of our senior leaders. Therefore, we take any allegations of misconduct very seriously, and where appropriate, investigate, and when substantiated, hold our people accountable when they do not meet our high standards. To be clear, there must be a violation of rule, regulation, or law. There's a process in place with many offices that handle this range of violations. Our primary role as the IG is to conduct administrative investigations, not criminal or UCMJ cases. When we receive complaints on flag officers from our hotline, Congress, or by referral from the DoD, we will open an investigation on credible allegations of misconduct against 1- and 2-star admirals. The investigation process is fair, deliberate, and thorough. Our investigators are highly trained and experienced professionals who rigidly adhere to the Council of Inspector General on Integrity and Efficiency Standards. We constantly strive through process improvements to produce ever more timely reports without sacrificing professional due diligence. Our investigators receive lots of oversight from our division directors to legal review to a DoD review and their ultimate approval. At the end of our investigation, all reports go to the CNO and the Secretary of the Navy. If any allegation is substantiated, we submit a request to the Office of the VCNO that appropriate corrective action be taken and documented. Corrective action can range from verbal counseling through formal disciplinary action under the UCMJ. We receive a copy of the documented corrective action, recorded in our database, and provide a copy to the DoD IG. This adverse information will remain in the officer's record for the entirety of their career. In the last 5 years, we have seen a steady decrease in the number of overall flag officer complaints and also a decrease in the number of cases substantiated. The most common categories of substantiated offenses we've seen were misuse of government vehicles and drivers for personal use, improper use of official travel, improper gift acceptance, and prohibited personal practices. In conclusion, I believe that our investigative process is a necessary and effective tool to address questionable ethical behaviors by our senior leaders. Thank you for your continued support for our sailors, Marines, Navy families, and veterans. I look forward to your questions.
Thank you, Vice Admiral Shalansky. Lieutenant General Harris, you now recognized.
Thank you. Chairman Kaufman, Ranking Member Spear, and distinguished members of the subcommittee, thank you for your invitation to testify before you today. And as the Air Force Inspector General, I'm responsible to independently and continuously inspect, assess, investigate, and report to the Secretary of the Air Force on the readiness, economy, efficiency, and discipline of our force. And with the Air Force core values of integrity first, service before self, and excellence in all we do, I take special pride in helping ensure our airmen live up to those values. Misconduct by Air Force senior officers erodes the trust in our service, the trust of our airmen, and the trust of our country. And your Air Force is committed to the development of ethical airmen leaders, and we are equally determined to ensure accountability when standards are violated. And part of my responsibility includes resolution of complaints against Air Force general officers, officers selected for promotion to brigadier general, and retired general officers. The top 3 categories of violations we've seen in the past 5 years may be generally categorized as ethics violations, improper handling of personnel matters, and unprofessional relationships in that order. And every complaint against a senior officer is diligently acted upon. Our cases are investigated by an independent team of investigating officers, augmented by embedded attorneys from the Office of the Air Force Judge Advocate General. And Air Force senior officer investigations are independent, thorough, impartial, objective, and we are careful to meet all legal requirements. This important work of ensuring accountability in our most senior leaders promotes the discipline, efficiency, and economy of our force. Our process in conducting senior officer investigations includes multiple layers of internal review, with every investigation receiving a separate and independent legal review signed by the Director of Administrative Law for the Air Force. And upon completion of each investigation, the Department of Defense, Office of the Inspector General, provides an oversight review, as was mentioned. Investigations with substantiated allegations are referred to the appropriate command authority to determine what disciplinary action is warranted. And finally, my deputy and I use a variety of venues and products to promote education and awareness across our senior officer population. It is important to me that we not only investigate complaints against our senior officers, but that we also work to reduce the incidence of misconduct by these high-ranking leaders. Mr. Chairman, Ranking Member Spear, members of the subcommittee, I very much appreciate the committee's continuing support of our Air Force and your interest in our efforts to prevent misconduct by our senior officers. I look forward to your questions.
Thank you, Lieutenant General Harris. Brigadier General Odignon, you're now recognized.
Thank you, Mr.
And
Chairman.
how do you say it?
It's pronounced Odignon.
Odignon, that's close.
Yes, sir.
Okay.
Thank you, Mr. Chairman, Ranking Member Spear, distinguished members of the House Armed Services Committee on Military Personnel. Thank you for the opportunity to testify today about this important topic. My office provides the Secretary of the Navy and the Commandant of the Marine Corps an impartial and incredible means to investigate or inquire into allegations of senior official misconduct, impropriety, or violation of law. I oversee a group of 25 dedicated professionals committed to upholding the laws that govern the service. In the past 10 years, 15 Marine Corps generals were substantiated by a thorough investigation process led by an Inspector General. Most of these cases were violations of administrative processes and standards of conduct regulations. None of them were criminal in nature. I have complete confidence in the investigatory process and due diligence taken with each and every allegation brought forward. Every general officer investigation is reviewed for legal sufficiency and requires Department of Defense Inspector General oversight. The seriousness of which the Marine Corps approaches character, leadership, and ethics is apparent in the demanding standards that we expect all our leaders to uphold. In the last year, my office has traveled around the globe conducting training with commanding generals across the Corps and conducting thorough inspections to ensure that the application of our standards are consistent with our foundational core values of honor, courage, and commitment. On behalf of the Secretary of the Navy and the Commandant of the Marine Corps, We thank Congress and this subcommittee for the opportunity to discuss such an important issue with you this morning and your continued support for our United States Marine Corps and its families. I look forward to the opportunity to answer your questions.
Thank you, Brigadier General Ottingham, for your testimony. So we're going to limit to 5 minutes each member, but we'll do a second round if necessary for the first panel. Some of you mentioned during your testimony that there is a wide scope of misconduct that you investigate. Could you please give some additional examples of the types of cases you investigate, and if you see any misconduct trends emerging? Why don't we start with you, Lieutenant General Quantock?
Yes, sir. I was just looking at the last year. We had 15 substantiations. The range of the kind of work that we do is late NCOERs. We had one particular general officer that basically lied on his PT test, height and weight type stuff. One that inappropriately approved a flyover, so misuse of government resources. Dignity and respect, how they treated subordinates, what they were substantiated for. Improperly using an IG investigation for adverse action at the junior levels was substantiated. So those are misuse of subordinate times, We've made a huge effort in trying to get after certain cases where general officers make technical type of mistakes with subordinates primarily. You know, we all have staffs, and a lot of times our staffs try to do good things for us, and they try to make our life a little bit nicer. We've beat the hell out of that last couple of years. We've got an exportable training package. When I sit down with the general officers that are going into command, we encourage them to sit down. It's about 75, 80 pages of PowerPoint slides, basically vignettes of what has got general officers in trouble. Again, a lot of technical violations from use of travel, getting rental cars, all those kind of things that sets folks up for trouble. Dignity and respect is publicly humiliating somebody. That's the genesis of dignity and respect. But that exportable training package, I think, is one of the leading reasons why in 2013 we had 32 general officers out of 685, I might add, down to 15 that we have in this last year. A lot of the technical violations have been weeded out. So we continue to work this piece hard, not to mention all of the efforts of the senior leadership to get out there and make their vision well known.
Yes, sir. So for us, over the last 3 years, a decrease trend-wise in substantiated cases. So 10 in 2015, 4 in 16. It looks like 1 will be substantiated for 17. We're finishing that case up now. You know, in general, most of the cases are about gifts, acceptance, and solicitation. So these are the technical, I'm going out to lunch and I accepted a gift of lunch from a contractor that was more than the acceptable limit. It's also in terms of endorsing non-federal entities. So there are certain charities that we're not supposed to, unless they're federally recognized, in our official capacity, we're not allowed to endorse them. So one of our flag officers was seen to endorse it inappropriately, but of course mistakenly did not know that at the time. Also, some pay and benefits. So for instance, leave statements, so inappropriate documentation of leave. And so those are very technical violations in general. So nothing in the order of larger, more, so in specific, no sexual harassment or any of those type of trends. So.
Thank you. The greatest majority of our violations have been ethics violations, as has been mentioned by my peers. Misuse of a subordinate's time, misuse of a government vehicle, unauthorized gifts, post-government employment. But what's most important is that how we proactively, within the IG enterprise, within the Inspector General enterprise, go out and educate our personnel from the most junior to the most senior on the different pitfalls and opportunities to lead the right example and to let them know what to look out for. And even there's complaints sometimes that people don't think that would be an issue. Giving out a challenge coin to a contractor would be a violation. But we continually educate our personnel on what the pitfalls are and what they should do to correct them.
Where in their career track do you begin that education?
From the very beginning.
From the very beginning?
Yes, sir.
Sir, in the last 3 years, we've had 4 substantiations. All of those were administrative in nature, violations of Marine Corps order for fitness report evaluations, for physical fitness evaluations. One was regards to training. So our trend lines are, as I previously mentioned, all administrative in nature.
Chairman Kaufman, if I could
Sure.
add, since we have oversight over all the service IGs, we have accumulated all the data on the types of misconduct in which we described on page 10 of my testimony. They generally fell into 5 categories: personal misconduct or ethical violations, such as improper accepting services from a subordinate, sexual relationships with subordinates, required subordinates to perform personal services for them, misusing your official position. The second one is improper personnel matters, which also involves unwelcome physical contact with subordinates and improper hiring. Third is misuse of government resources, such as using vehicles to commute improperly or misuse of government aircraft. And the fourth is travel violations, traveling for purely personal reasons. And the fifth is other, for such things as improper procurement, steering contracts, for example. On page 11, we discuss the trend lines, and the trend lines are generally down, but they're still significant in these categories. And of particular interest, I think, to the committee is the inappropriate relationship category. On page 12, we talk about how many there are across the services, and there has been a steady number of them. There were 10 in 2013 substantiated findings, and in the subsequent years.
Mr. Fine, I'm afraid I'm out of time. I have to. Ranking Member Spear.
Thank you, Mr. Chairman. I'd like to put a chart up, if we could, that shows each of the services, and this is for you to start, Mr. Fine. So in the Air Force, the total closed cases were 54. 54 were dismissed. 0 were investigated in the Air Force. In the Army, 101 dismissed, 0 investigated. Defense Agency, 111, 110 dismissed, 1 was investigated. 36 in the Navy, 36 dismissed, 0 investigated. Are you basically saying that none of these cases even deserve to be investigated?
So that chart, Representative Spear, I think is from our semi-annual report for a 6-month period.
It's one half of a year.
Yeah,
right.
For half a year in 2017. What we have is in my testimony is a chart describing the number of cases involving senior official misconduct overall for the last 10 years, and there is a substantial number investigated. The chart that you that was up there has to do with, I think, 3-star and 4 stars, which are the highest level ones. And so this chart has to do with senior official cases, including 2 stars, 1 stars, 07 promotables, SES employees, et cetera. We do look at all these cases seriously. We do intake. We determine whether it warrants an investigation. And these are the ones that did warrant investigation against the high-level officials who was investigated against. But as you can see from my chart on page 8, there is a significant number of ones that are investigated and are substantiated.
So, but I'm totally confused then. It says that 0 of these, out of 312 cases, 311 of them were dismissed.
Yeah.
So only 1 was investigated. Are you basically telling us that all of these cases were bogus?
No. And what this chart also does, it's probably a confusing chart. The top part is the DoD OIG receiving those cases. Many of them are referred down to the service or agency and are investigated and closed by them. So if there's 54, for example, that we get, these are the numbers we investigate, and we refer them down to the Air Force, the Army, the Marine Corps, and the Navy, and they investigate them and have investigated many of them.
Well, it's still not making any sense to me.
Okay.
So there's 54 that you receive from the Air Force. Why do you use the term dismissed if you were then forwarding them to the Air Force IG?
Yeah. So we receive far more than those, and we refer many of them, 12 of them, to the Air Force, for example. And of the others, we do not. We do intake and determine they don't require an investigation, but there are a number of them that do require investigation, as indicated by the chart below, the numbers below.
Well, the numbers below are the ones that are investigated by the service IGs.
Right.
You're not it looks like you're not investigating any by this chart. I don't want to take a lot of time on this. I think this chart needs to be reviewed, and I'd like for you to come to my office, and I don't know if Mr. Kaufman would be inclined to hear more about this, but this is deeply troubling to me. All right. In one of the cases that I mentioned, there was a recommendation by the IG of holding someone accountable for substantiated claims. And then it went to in this case, General Dempsey, who just struck one of the substantiated claims. How often does that happen?
We have a chart on page 14 that it happens sometimes. Of the allegations, of 427 allegations of substantiated misconduct over, I think it's a 5-year period, 29 of them declined to take action, and about 80 of them are still pending. So in a small percentage of allegations, the services declined to take action.
So you're saying, can you just, did you not present your document to us until yesterday? Is that what the
We
situation
provided
is?
it
So I
yesterday.
still don't have a copy of it, unfortunately. Can you just go over that for me?
Certainly. On page 12, we discuss corrective actions by rank of senior official, and this is over from FY 2013 to 2017, and we describe the actual discipline corrective action that was taken, ranging from a letter of counseling to suspension to removed from assignment. Of those, the top line is declined to take action. 29 of the 427 substantiated allegations, the service declined to take action.
All right. Would you please provide for me, in those 29 cases where they declined to take action, the specifics? Because I find it unjustified to have inspector generals go through the process of determining, through investigation, conduct that is inappropriate, have that be presented to the chiefs, and then have them just strike it as if it doesn't exist, as it happened in the Custer case. I mean, that's fraudulent as far as I'm concerned. And with that, Mr. Chairman, I'll yield back.
Mr. Bacon, you're now recognized.
Thank you, Mr. Chairman, and thank you all for being here today. I want to keep a couple of questions for the 4 service reps, give you a chance to think about it, because I'll go to Mr. Fine and ask him a couple while you're stewing on a couple of these questions. But I find most commanders try their best to do the right job on these things, but they're imperfect. Some of them have made bad decisions, just as some judges have, just as some district attorneys have. We're imperfect, but I think we strive to be the very best we can and try to get as close as perfect as we can. So one of the first questions I'm going to come back to you all on will be, if we take commanders out of the discipline and accountability process, what would be the impact on the mission or the impact on morale and unit integrity from your opinion? Secondly, how would you address the ranking member's point that there are different spanks for different ranks? So I'm going to come back to you all on that, give you a chance to think about it. Mr. Fine, my data shows we have 2,327 senior leaders, 963 of those are general officers. Roughly, if you could just give an average, what would you say, how many allegations are made a year against those 2,327 senior leaders?
About 800. In our testimony, we discuss how many have been made over the last 10 years. In 2008, there was 395.
So 395 out of
2008.
2327.
Now, in 2017, there's 803.
800?
Yeah.
That seems like a lot for 2,327 senior leaders.
Those are the allegations, correct?
Okay, out of those allegations, how many substantiated, just to put it on record here?
83.
So 83. And what would that come out as a percentage? I guess it's 34%, I think you had, of the allegations that were substantiated.
Well, of the cases that we actually investigate, 30% of them are
About
substantiated.
30% are substantiated. And they range from overdue reports to the more serious.
Correct.
So many of these are things that would nowhere would be considered criminal in the private sector.
Most of these are very few, a very small percentage are criminal.
If you just give me your thoughts, how many would you say senior leaders have done something criminal, sexual assault, for example, out of this last year's data? 1 or 2, 3 or 4?
Very few have done criminal misconduct, except I will mention the GDMA case, the Francis case, which is a whole nother
Which is
thing.
criminal.
Yeah,
Got it.
Which is criminal.
So we're talking less than a handful out of this 2,300 plus senior officers have done something criminal.
Yes.
Thank you very much. One other thing. One of the things that concern me as a 5-time commander is the length of time it takes to investigate. When you have people under investigation for 2 years and then exonerated and their career's over, it seems to me that we have to do something better there. I mean, I just as a person, I've never been investigated, thankfully, in 5 commands, so I've been blessed, thanking the Almighty. But I know some people have been under for 2 years, and then they're exonerated. And you're like, man, what? I mean, is there anything we can do better there?
I think there is. We do strive for timeliness. We recognize that when you're under investigation, your promotion is held up. Sometimes you can't retire, you can't be moved, and it's difficult to be under the microscope. And many of them, most of them are clear to the end. So we do strive for timeliness. With the number of investigations, the number of complaints, the resources, we also want to be thorough and accurate. So it's a balance there. And some of them we could handle quickly, some of them take longer. Having said that, all of the IGs, we and the service IGs, are moving to try and increase our timeliness without sacrificing quality, accuracy, and thoroughness.
Well, thank you. Now I'll go to our service reps, and I'll go to the first question. If we take commanders out of the process here, what do you think the impact is on your service?
Sir, it would be absolutely devastating. I've commanded from company all the way up through 3 times as a 2-star commander. Absolutely devastating if you take. We are not Walmart. We send soldiers to do very dangerous things. I lost 13 soldiers as a brigade commander, over 200 Purple Hearts. I tell them to go out there and protect terrain, to escort convoys. They put their lives on the line. So some folks, may have problems with some of the orders that I give. But we have to give them. So it would be devastating. So to be able to have control over the carrot and the stick, for another word that you could use, carrot and the stick, you got to have a lot of carrots, but you also got to have the stick to hold people accountable and to uphold the high values that we have in the Army that are not that are not really applicable to Uniform Code of Military Justice. Right. It would be absolutely devastating, and we are right now the greatest service the world has ever seen, and we would become a third world country, a third world army, if we were to remove commanders from the Uniform Code of Military Justice.
General Quantock, thank you. I'll come back on the different spanks.
Okay.
Admiral Schlansky.
Yes, sir. I'll agree with General Quantock. Certainly, it's about good order and discipline. And in terms of having the UCMJ capability at the commander level is essential for that good order and discipline and the morale of the crew, because they expect also fairness and justice throughout their command, and they hold each other accountable. And when one of their shipmates is not doing the right thing, they want them to be held accountable, and that's got to be done quickly and efficiently.
I saw that in the Air Force. We had a commander downgraded court-martial, and he was held accountable for it. With that, Chairman, I will come back for my second round to finish these 2 rounds of questions with our service reps. So, General Harris, I'll come back to you later on my second round. With that, thank you.
Ms. Songus, you're now recognized for 5 minutes.
Thank you, Mr. Chairman. I think we would all agree that the military is a rightly honored institution. We would not be the country we are without it. But as we've heard, and it's so true, it's not perfect, and those serving are not perfect. So it's important that there is a process in place to look at senior leader misconduct. So as we engage in the oversight of this process, and I'm grateful for this hearing, I think we have to be reassured that the process is not biased in favor of those senior leaders being investigated. So I have to say at the outset, it really concerns me that in each service, it is a general officer who functions as an inspector general. It just seems to me that there's an inherent conflict there and possibly an inherent tilt in the process in favor of the general officer. I don't necessarily want you all to comment on it, but I think it's something that we all have to take into account. But given that that is the fact, I'm curious who provides oversight of all your work and makes sure that there is no inherent bias, that it is being performed correctly to be sure that we are truly identifying misconduct and holding general officers responsible. So I'd like to start with you, Mr. Fine.
So we as the DoD OIG do provide oversight over the service IGs. We review their reports to make sure that they're thorough and complete and have done all that they should do to track the leads, to investigate, to interview the appropriate people. So we do that level of oversight. We also have begun doing what we call quality assurance reviews, similar to a peer review, to look at their processes, their procedures in a systematic way to make sure they are following the rules and regulations and they are adhering to quality standards and are doing the right thing. So we provide that oversight. One of the questions that's often asked is, well, who oversees us? We are overseen by other IGs. The SIGI has a peer review process, and we're also regularly overseen by the GAO. So there is oversight over us, and we provide oversight over them, and that's a good thing.
Do you have the ability to refer a case back if you think it hasn't been appropriately investigated?
Yes, we do, and we do that.
And how often have you had to do that?
I don't have the exact numbers, but there are occasions when we do that. We review the report, and there's times where we think they have not fully investigated or if they've reached a conclusion that's not supported by the evidence, we refer it back to them for additional work.
I don't know if each of you would like to comment how you can do your job in a way that you feel is fair-minded, given that you represent and come out of the service you're overseeing.
Yes, Congresswoman. I would just say a couple things. Number one is my last job, I was a CID commander, so when I left that job, I had 3 friends. And after this job, I have no friends. So the fact that, this is not a highly sought after, well, maybe something, a highly sought after job because we make hard calls with the DoD IG oversight is a very fair process. Just about the investigators that do a majority of my cases are civilians. So and many of them have extensive years of experience. One of my investigators has got 18 years. Another's got 10 years of these kinds of cases. So it is very well. And not only that, we have many levels of legal review of these cases to ensure we're doing due process, both for the complainant and for the subject. Once an investigation is done, legal review. After that, it goes to my lawyer. He does the legal review. After that, it goes to the Office of General Counsel for their legal review. After I've had 3 legal reviews, and I've read the case, and I understand the case, and I agree with the findings, I sign the case.
And are the findings conclusive, or can you reject the findings?
I have never rejected the findings that have been brought to me. So after all of the scrutiny that goes on with these things, I can almost exclusively say I don't think I've overturned one case that has been brought to me. I sign it, and it goes to DoD IG for their oversight review. So it is a very fair and thorough process.
So it's only somebody higher up in the chain that could reject the findings, or would likely reject.
Well, after we get done with the case, it gets adjudicated for cases, and that's what happens. Once it comes down as substantiated, we're just calling balls and strikes. We're saying, did they violate a regulation, yes or no? If the answer is yes, the substantiation holds, even if it's for small technical violations. Then it goes, after the DoD IG review, it goes over to the lawyer side of the Army, the TJAG. The TJAG basically puts the case together and brings it to the adjudicator, the Vice Chief of Staff of the Army. And the Vice Chief of Staff, under advice of counsel, holds the person accountable according to due process and according to the facts of the case and what he's been substantiated for.
Well, I appreciate, we don't have time to hear from everybody, but I do think it's deeply concerning that you are generals in the service you're overseeing, and I do think a civilian oversight perhaps would at least eliminate the appearance.
Congresswoman, we have a lot of civilian oversight, but our Army is made up of soldiers. Okay, the vast majority of our Army is soldiers, and I believe, having been a commander a number of times, I also can look at the case and also understand, because again, we're representing the Army. I am the Army Inspector General. And I think from our soldiers' perspective, at least the vast majority who are soldiers and know the fact that the person calling the shots at the IG has been a former commander themselves from the time I was a captain all the way through up to my last position, I think it's important that person is a soldier, a sailor, and an airman Marine.
We could agree to disagree. Thank you. My time is
up. Yes, ma'am. Thank you.
Dr. Abraham, you are now recognized for 5 minutes.
Thank you, Mr. Chairman. Just a statement first. As a congressman, and certainly I think as the general public, we want to know that the process is intact. And what I'm hearing from the panel is that the process is good and that it is accountable and, more importantly, it's responsible for the actions that are found. Certainly, as a physician, I am judged by my peers on the physician side. So, you know, I think it's you've got to have peer review, and I certainly don't think there's any conflict there from being reviewed by your peers. When I've asked for private conversations with several of the vice chiefs behind you, I've gotten them, and there have been very forthcoming answers to direct questions. So I appreciate the openness that you afforded me. So again, just a statement that I like the process. I think the process is good, and what I'm hearing is that the process is working because we are seeing a decrease not only in the severity of the accusations, but in the total number too. And I'm going to yield the rest of my time back to General Bacon so he can continue his dialogue.
Thank you. What would be the What would be the impact of taking the commanders out of this discipline process? General Harris, what would be your perspective from the Air Force?
Sir, I agree with my peers. It would be absolutely devastating, and it would erode the good discipline and order of our force. And then as far as disparity in punishments, our data that I've reviewed doesn't support that. We hold our officers actually to a higher standard of accountability. And there's actually 2 other articles of the Uniform Code of Military Justice, 133, which is conduct of becoming, and 134, which is fraternization, which holds us accountable.
Thank you. General Ottingham.
Sir, I agree with my peers as well. I think removing the commander from the process would have grave implications to the good order and discipline organization, a fighting organization. And I agree also that the data doesn't show that. I think we hold our senior leaders more accountable in the Marine Corps.
Thank you. Going back to General Quantock and Admiral Shalansky on the different spanks or different ranks. Any feedback on that?
Yes, Congressman. I would tell you, if I had to look at all the cases that I have looked at, and my last job as a CID commander, and of course now as the IG, that's about 6.5 years. I would tell you it's hugely swayed on the part of a general officer being crushed, okay, for substantiation. And how is that? Well, what is the most egregious? Usually, the most egregious kind of offenses that we have general officers inappropriate relationships. Now, I have adjudicated sergeant first classes, junior soldiers for inappropriate relationships. They would get a letter of reprimand. Same thing that we would give a general officer, a letter of reprimand. However, on the general officer side, they're done. And the sergeant first class isn't going to get promoted either, but he isn't going to go backwards. That general officer is done. Okay, and a lot of times he will retire at a grade a lot less. So he is effectively being fined. And in case for retirement, hundreds of thousands, if not millions of years when you have a major general go back to the rank of a lieutenant colonel. Now, we can discount the fact that that soldier has been in combat multiple times. And that's what we'd like to do sometimes by saying, well, we should just take his retirement away. But what we have done is separated him from his family multiple times, sometimes years at a time. And then we say the person doesn't deserve anything? Again, a lot of times we forget about that. None of us at this table came in the Army as generals. I spent 27 years coming up the chain just like everybody else. And I've been 11 years as a general officer. I can tell you we crush general officers. And should they be crushed for these kind of offenses? Absolutely. They know since the time they were second lieutenant what's right and what is wrong. And when they do it, they expect the consequences. And we should hold them accountable.
I know I felt that way as a general officer in the Air Force. Thank you. Admiral Shalansky.
So I agree. And one particular case that we would have that I could give you as an example. So a flag officer viewing pornography on a government computer on a ship. That type of work, should it have happened with an enlisted sailor, that enlisted sailor would probably be brought to mast, probably reduced in rate, withheld, pending further, 6 months, and then taken their rights away to utilize that computer. And then once that 6 month was up, they'd be back in their job, continuing as a sailor on board the ship. The flag officer removed from his position, his command, and retired as an 06. Much harsher and much more deeply pressing for his career.
One question, I'll just leave for anybody's, if they want to answer the question. Does anyone here think it would be better to bring a judge from the outside to adjudicate these? Or does anyone here think a district attorney outside of the military would do this better?
Only if we want to make the system much, much longer and hold people in suspended animation forever. That's the problem when you go to a purely jurisprudence system. Right. We all have advice from SJAs. We're not legally minded, but I get advice as a commander from many different individuals. So I think that would be a huge mistake. Also, what I've been trying this 38 years that I've been in the Army, I've been trying to find the perfect profession. So as I look around all of the professions out there, I haven't found one. We are not either. But we try real hard to be that. And we hold people accountable, even for minor discretions or minor violations of Army regulations.
Yeah. Thank you very much, and I thank Dr. Abraham for yielding to me, and back to the chairman.
Dr. Winstrup, you're now recognized for 5 minutes.
Thank you very much. Thank you all for being here to approach a very difficult topic for everyone involved. I will say, and especially with what you just said, General, they say to whom much is given, much is expected, although I wouldn't say rank is given. It is often earned, but the expectation is much greater. And I think that's a fair assessment. You do expect more from your officers, and especially your general officers as you go up in ranks. So I appreciate that feedback. Mr. Fine, you mentioned earlier about the gathering data from the IGs. So what do you see down the road with this? Is it going to set maybe a tone for what type of punishment is appropriate, or what legal actions we need to take? What do you expect to gain from that as that comes together?
Well, we regularly gather that data and I think it's important to report that for transparency to see what is going on, even by service and by rank and by offense. So we will continue to do that. Provides transparency on the process, which is a good thing. I will mention one thing that we intend to do is also to look at this issue about disparities. And we are going to open a review and evaluation to see if there are disparities that jump out. Now, sometimes the disparities are because the cases are different, and that's very hard to analyze. But I think in some ways it's important to look at the overall statistics, the numbers, and see if there are anomalies that jump out, either by rank, by service, by gender, by race, by all sorts of stratifications, and we intend to do that. I think that's a useful exercise.
So you're really looking for, I guess, best practices, if you will, when it comes to setting guidelines. I mean, every case is different. And so you don't want to say this is the mandatory sentence for this, because you want to take the case in its entirety. But are you expecting to have guidelines from this?
No, I don't think we're going to have guidelines. That's up to the services to implement corrective action. But it's important to see what is happening and to analyze that and to evaluate that. In terms of guidelines, though, I do think there ought to be standardization and guidelines for how we conduct the investigations, and to make sure that it's relatively standard throughout the DoD, so that if you're subject to an investigation in the Air Force, you're not going to be treated differently than if you are in the Navy. I think that's helpful. That's important, so that there's standardized, timely investigations, and we intend to look at that as well.
So are you far enough along at this point that where you would maybe be making suggestions or just pointing out the differences? Or
in terms of the standardization?
Yes.
Yeah, I think there are some suggestions that we have made and we will continue to make. One, there ought to be a standardized case management system, a database, so that we all use it, so that we track it and record it in similar ways and we share information in a similar way. I think we ought to sort of consider formats of reports to be standardized. That will speed things up as well. I think we also ought to consider, there may be some disagreement here, but sort of a tentative conclusion process to give the subject an opportunity to comment on the report to show if it's inaccurate or not. We do that. On the other hand, that does lengthen the timeline a little bit because it gives them time, and sometimes as a result you are required to do more work, and that is the trade-off. But I think that's a fair process and gives them fairness and due process, and ultimately we'll make the decision on what's the ultimate finding. So I think those are the kinds of things that could be useful to standardize, and I've had discussions with the service IGs as well on that. We will continue to pursue that.
Well, thank you very much, and I want to thank you all for engaging with us on this very difficult and important issue. Thank you. I yield back.
Mr. Kelly, you're recognized for 5 minutes.
Thank you, Mr. Chairman and Ranking Member. This is an important hearing. I want to go back kind of on the line that General Bacon had, or Congressman Bacon. Members of the service, especially senior level leaders, whether they be command sergeant majors or general officers, would you agree that they are more hard on people for disgracing their uniform and their rank and their awards than a civilian would be? Because many times do you think civilians are in awe of the things that you do and therefore kind of give you a pass because of your service, and a sitting other general who's done the same service is less likely to be in awe of your career and the things you've done? Would you agree with that?
Well, sir, I would just say that I don't know if awe is the word. I think respected. My father was a Vietnam vet. I will tell you the way they treated back in those days was incredibly poor. But I will tell you there's a lot of respect among us. But yeah, of course, the people that understands the culture is a big deal in the military, and it has evolved over time. I've seen huge changes for the good since 1980 to the present day, and we continue to change that culture for the good. But to make a complete statement that civilians, I mean,
not necessarily in all, but they tend to give you the benefit of the doubt when maybe a peer or someone of the same or a higher rank would not want their uniform.
I would absolutely agree. The professionalism or non-commissioned officer corps is second to none. And I have sat on many promotion boards with them, and they get down to the standard of a particular individual, down to the...
Let me rephrase. Would you, as a general officer in your job, cut someone a break, another general officer, because they're a general officer? Or would you be harder on them because they disgrace the rank that you work so hard to earn?
So I agree, harder. Absolutely.
Absolutely.
And I want to go back just a second, General Quantock. I think we actually have been in the same places a couple of times. I looked at your bio, and I was at Taji in 9 and 10, and I think you were overall. And, of course, we had a facility there. I want to ask you, Lieutenant General Ed Cardon recently commented to the AP that the Army is reviewing ways to improve senior officer corps through pilot initiatives. And can you please expand on one or more of these initiatives and explain how they reinforce ethical behavior in general officers?
Well, I will just tell you, it's a holistic study by the Chief of Staff of the Army, and the Vice will have much more on this than I do, but really it is a study on basically health of our general officer corps. Particularly over the last 15, 16 years, we have run this general officer corps into the ground, not to mention our soldiers. Our sailors, our airmen, and the Marines. We have run this force into the ground. Many of us have been away from home years at a time. But we never take a day off. When I'm on leave, I'm attached to my BlackBerry and on my phone. My wife and I have these discussions many times. Okay? I am never disconnected from the Army. I lose leave every single year. Even though we make sure that our subordinates take their 30 days of leave, we never take, we put it over weekends, we don't take any leave. So the health of the force really requires us to give those general officers a little bit of reprieve. So from making them take their leave.
Let me move on to the next question. Yes, I want just a little more answers on things. In my experience in the military of people going forward for GO boards or general officers or senior level leaders in the military, it's been my experience, my personal experience, that I've seen far more people punished and prevented an IG complaint to hold up a guy who the promotion board goes past his MRD and so he never makes general officer, or he doesn't make 06, or they don't make 07 or 08. Has your experience been that far more senior leaders are punished by being held or flagged for negative transactions by a IG complaint that is not substantiated as to those who get away with doing something wrong and never get punished?
Yes, sir, and that's the elephant in the room. That's the whistleblower reprisal issue. When we talk about numbers, whistleblower reprisal has skyrocketed because of the misuse and misapplication of whistleblower reprisal against senior officials. It is off the charts. I've been investigated twice for whistleblower.
Let me just real quick, and you guys understand. Junior members know, or junior members of the military know, that they have a commander they don't like for some reason, that if they file an IG complaint at the right time, it can end his career even though they've done nothing wrong and nothing to substantiate. Is that correct?
That is correct. So we can see a rise in complaints right around the time that the list comes out.
Mr. Chairman, I yield back.
Ms. Rosen, you're now recognized for 5 minutes. Mr. Russell, you're now recognized for 5 minutes.
Thank you, Mr. Chairman, and thank all of you for being here. I guess, Mr. Chairman, I don't understand why members of Congress want to trash the Uniform Code of Military Justice. It is the one glue that holds our military together. We can critique it, we can oversee it, we can hold it accountable, but God forbid if people in the political environment ever trash the Uniform Code of Military Justice and get rid of it. You think we've screwed up the military good now? Put it in the hands of, with no UCMJ, and put it out there where we have people with no understanding of the institution that create Lord knows what, good order and discipline, decisions, battlefield decisions that commanders have to make. That would all be eroded and gone. And we'd feel good about it, and then we'd hold our hearings and pound fist on tables and point bony fingers talking about what went wrong as honorable people sit here before us and holding them to account. And yes, Mr. Chairman, I am on my high horse. How many of these offenses, General Quantick, were discovered outside of the military?
Sir, I can think of one where actually it was an individual that decided to go.
So
to
only
press.
one out of all of the hundreds or even thousands of accusations, they were all discovered by the institutions.
Yes, sir. Some
now,
anonymous.
Where I come from, that's the hallmark of professionalism. You don't see that at IBM, and God knows we don't see that here in Congress. So I guess the question would be, why is it we think that it's a broken system? Yes, we have problems. Yes, we see oversight that Congress has to be responsible of, and we have civilian control of the military, and that is the great republic that we all serve. But it's somewhat a little bit offensive to suggest that the institution is unprofessional or somehow broken because it discovers its own problems. In the business community, people would love to have those problems. Congress, gosh, we would love to have our own accountability where we discover the problems before the American public does. In terms of generals overseeing the military, wow, gosh, yeah, I mean, that's kind of like members of Congress overseeing government. How could that be? The military has a better rate of accountability than society as a whole, certainly better than Congress, and perhaps even better than Hollywood when it comes to offenses and things like this that we see. So I guess my question would be, what would be the damage that we see as we continue to inflate the problem? Not saying ignore the problem. We have to take these things seriously. We have to hold them to account. We are doing that. We see that. But when it becomes inflated, and as was mentioned by my colleague from Mississippi, IG complaints come up, and then, you know, here come the investigations. And I've known many great warriors who were held from senior level command, were later exonerated after a 2-year period. They would have been able to keep men and women alive in battle and do great service to our republic, but they never got the opportunity because. Could you speak to some of the other problems in your capacity as Inspector General, that when someone is exonerated, do they ever get their life back? Are they ever restored, or does the ship just pass them by?
Sir, both happens. Sometimes the ship, it's based on timing. But sometimes the ship sails because investigations take long. I will tell you, just the other day, a couple months ago, I had a division commander, just came back from Afghanistan. And I won't talk about his name, but he comes in my office. He said, "Sir, I'm getting ready to resign. I've had it. I've absolutely had it." Disgruntled employee, a week before his change of command, knowing the effect of it, throws an allegation out there. Now, what happens is, of course, we spin up any investigation. He is flagged, no award at the end of a division command, despite of his sacrifices to himself and his family. The Force Com commander was coming down there to pin an award on this guy, but that's off. But he still was going to pin an award on the spouse. The spouse told her husband, said, "I don't want the damn award." Okay? So the families also were impacted on this because they also sacrifice. So one day we're going to wake up if we keep this. We're going to wake up one day and we're going to realize who the heck wants to serve. Because we put people through hell. We put families through hell. We put the soldiers through hell. We work them like dogs. We deploy them into combat. We bring them back, and here's your thing. So you're leaving without a award. There's this cloud over your head, possibly lost your reputation. And then eventually he will get exonerated, and then he'll be, because I've looked at the case, there's nothing there. But this is the whistleblower reprisal. I have been investigated twice for whistleblower reprisal when I came here because I held somebody accountable because they beat up a CID agent, beat up his weapon, pulled his weapon on his neighbor, and because he sent a protected communication to Congress about wanting to deploy his unit, said no. I got held up for 6 months. Or I downgraded an award from an MSM to an ARCOM. I had an awards board. I had no idea about the protected communication. Another 4 months. We do this to the General Officer Corps, not to mention to the entire Army, all the time. The reason why the numbers are so high from DODIG about the rise in complaints is because the misapplication of whistleblower reprisal. The law is good. It talks about gross waste of funds. It talks about intent to kill or cause serious bodily injury to members of the armed force. It talks about grievous things, not downgrading an award. That's the problem. We have hijacked the system, and there's a dark cloud over the General Officer Corps because right now we are getting hammered.
Well, I thank the chairman, and the only parting comment I'll say is that people are dragged into the IG to serve in IG capacities. They pick them from some of the best performing folks that are out there. They go kicking and screaming. They don't want those assignments. They call all of the favors in to try to avoid them, and they still have to go. And so my hats are off to all of those that serve in our inspectors general departments within our military. Thank you, Mr. Chairman. I will yield back.
Ms. Spear, you're now recognized for 5 minutes.
I feel compelled to speak because we have an obligation as members of Congress to do oversight. When 400 service members are implicated in the Fat Leonard scandal, when over 60 admirals are potentially implicated, we have an obligation to look at the process. So I take great umbrage, frankly, that it is suggested somehow that we don't have a role here. The Uniform Code of Military Justice is not on trial here. We live by the Uniform Code of Military Justice in the military. I mean, there are elements of it that I'm not particularly excited about, but for the most part, it is frankly, a victim-centered code. We've made some changes over the years, but what we're really looking at is a couple of things from my perspective. Why is Congress oftentimes the last to know? We have oversight responsibilities. You should come to us when you've got an issue with a senior officer and let us know, so we're not reading about it in the newspaper. When you have a scandal like the Fat Leonard case in the Navy, it's incumbent on us to look at that case in particular and see, why is it no bystander? No bystander felt that they could come forward. And to Lieutenant General Quantock, whistleblower protection, I would argue, is not enough protection, and that's why people don't come forward, because they fear that there will be reprisals. There were too many people that were engaged in conduct unbecoming officers in that case, and no one called them out. Now, let me now ask a question. I'd like from each of you to know what your backlog is. Quickly, if you could.
We have a significant number of open investigations, and we report them.
Do you have a number?
I can get you the exact number.
All right. Yeah. I just want to get numbers at this point to see whether or not we've got staffing issues.
We do have staffing issues. The complexity, the number of cases have risen, the number of cases that we have to do, and we take them seriously. We take each of them seriously, and you can only do more with less for so long, and it does affect the timeliness of the investigations and how long people are hung up. So I do believe that it's important to adequately resource IGs, both us and the service IGs. They're not the first people that they think of when they're growing the military, but you need to grow them.
Okay, I've got limited amount of time. How many additional staff do you think you need?
We could use 100 more additional staff. We have 1,600 employees. That's not that much. I think we could use a significant number more.
All right.
I mean, I could give you more statistics and sort of basis, but we need significant resources, as do they.
All right, Lieutenant General.
Yes, Congressman. We have right now 50 open senior official cases going on right now. I have 20 investigators. I could easily double that. The average case is about over 400 days. Whistleblower reprisal, a separate division. I have another 20 people doing that. I have 345 open cases. Average length of a case is 391 days.
Okay, thank you. Vice Admiral?
Yes, ma'am. We have over 200 cases that are open at this time, and we are just now finishing up and getting up to our 2016 cases. So there is some lag time because of the numbers of investigators. But I'd have to give you a specific number later, if that's okay.
All right, thank you. Lieutenant General?
Congressman, we welcome the opportunity to partner with you on assessing our needs for plussing up our forces. I'd like to take that question for the record and understand that our average investigation takes 187 days.
So yours take about half the time as the Army, is that right? Sounds like?
It sounds like it.
I think we should probably look at that. Why is it that one service can do it?
One service is much bigger than the other service. The amount of service members does have an impact, but I'm not sure. I have to look at the numbers.
Yeah, I think we should look at the numbers. Yes. Brigadier General?
Ma'am, I have 11 open cases on general officers. I have 26 whistleblower reprisal cases open. I have 300 total cases, just over 300 cases open. I average 233 days for a senior official investigation, and the remaining investigations are upwards of 300 days.
Okay. I think we need to be sensitive to the time it takes for these cases. We need to up, I think, the service to the person who's charged and to those who are actually providing the work among those who are employed. At another point in time, I'd like to know, in terms of your investigators, how many of your investigators are civilians? So I'll take that for the record if each of you could provide that to me, as compared to those who are in the military. Thank you.
Mr. Abraham, you're recognized for 5 minutes.
Just to follow up, again, the process is good. In my opinion, it's working simply because of the results that y'all have had to this point. Moving forward, General Harris, you mentioned it a little bit in one of your answers. Since this is an open hearing, let's let the general public know, what are the services doing proactively from that second lieutenant up to that 4-star to help prevent this from occurring over and over again?
Thank you, Congressman, for the opportunity to respond to this. So proactively, 2 areas, prevention and training. So first, training. So from the youngest airman, whether you're officer or enlisted, through every course of leadership that you go through, you have an ethics training, whether it be squadron officer school or airman leadership school, all the way up to the senior leader officer course, which general officers attend. Proactively, in the Inspector General system, of course, we have our inspection process. And so not only are we assessing the readiness of our force, but we're assessing the culture of that force also, and providing that feedback to the commander. Reactively, of course, the IG investigates fair, accurately, and thoroughly any investigations, any complaints that we have to ensure that we are offering due process and upholding the standards of our service.
Other members, General?
Just briefly, sir, I would suggest that it begins at the beginning of boot camp. It begins the beginning of officers candidate school. It's reinforced through every service school as they continue in a career, both enlisted and for officers. Becomes much more acute as a general officer upon selection, annual requirements that we meet each year, as well as my office providing additional training each year in the field. So it's often and it's more focused on the ethics piece throughout that year.
Admiral?
Yes, sir. Like the generals just said, from the beginning, so midshipmen, whether in ROTC, at the Naval Academy, or Officer Candidate School, get their first taste of ethical training. That goes up all through their career. It's mandatory when they reach 05 command that they go up to the Navy War College, where they go through the Navy Leadership and Ethics class, and then onward from there as a flag officer. When they first become a flag, they have ethics training. I personally go to many of these classes. In fact, I either virtually or in person to talk about cases and where fellow commanders and flag officers before them have crossed the line.
General Contact?
Yes, sir. It's similar across all the services. The addition thing is that we put a lot of focus on the general officer education, many different levels. That every time you make a step, you're getting an ethics brief. Every year you're getting an ethics brief. I would also say is that we also have to really get after it at the battalion and brigade level, lieutenant colonel and colonel level, at our pre-command course. We've extended it to 2 weeks, so they get SJAs, and of course they get me for an hour and a half. And I have not missed one in my 3.5 years as the IG and 6.5 years when you talk about my CID time, because prevention is really the key. If we can prevent people from walking into mistakes, that is the key. Totally. And 99 2/3% of our soldiers out there want to do the right thing, but sometimes they walk into it. So our goal is to prevent that from happening.
Thank you. I yield back, Mr. Chairman.
I recognize myself. One of the concerns is the length of time that it takes to go through this process. One element of that is certainly the resources in terms of the number of personnel we're throwing at it. But is there anything we can do procedurally to change the process to hasten it, to get, it's unfair to a lot of parties just to tie this thing up for so long. Mr. Fine, do you have any recommendations?
I do think a uniform process could help speed things up, standardized databases, standardized formats, so that we know what we're doing and we can do that more quickly. I do think there ought to be sort of assessment at the front end in the intake level, whether there is sufficient indicia of credibility that it warrants an investigation. And then if there is indication as the investigation is going along that there is a fundamental deficiency in the allegation, that it's not substantiated, we can close it in a reasonably timely way. So I think those are things that can be done. And I do think resources, as I mentioned, is significant.
Any other comments on this?
Yes, sir. The point that I make, and if I haven't mentioned reprisal, I'd like to mention reprisal again. 40% of my senior official cases are caught up in reprisal because they basically have held somebody accountable. So some better guidance to DOD on how they basically interpret reprisal law, so that just the significant ones fall under that and not everything. Downgrade an award, hold somebody accountable because they beat somebody up and pulled a weapon on them. Somebody had a doc who was on cocaine, reprisal. I mean, it goes on and on and on, the amount of cases, because all I have to do is have a protected communication followed by any kind of unfavorable personnel action. We are off to the races on a whistleblower reprisal case. And again, average time is 391 days. If we could get some help, some guidance on that piece, I mean, again, it's good law. Okay. I mean, it was there for very good reasons. But we could get some help in that particular area. That would help on the resource piece as well.
Okay.
Yes, sir. We've initiated a couple prototypes about intake analysis, and it's been very profitable in times of time saving. So we continue to look at process improvement. But part of the issue, besides that, is IT. And I think, as we continue to have to scan documents and manually input things into the computer system, it's a huge waste of time. The effort by DOD to make one type of system that we all can manage electronically eventually will save us a large amount of time and effort that right now is taking up with just antiquated systems that just eat up a lot of time.
Our timeliness factors are really based on the complexity of the allegation that we're investigating the volume of complaints, and then the availability of witnesses takes great time. But last year we ran a process improvement event, which got us down to the 187 days, and of course we're still looking to get it down even further.
Sir, I would say that the Marine Corps is very supportive of that law. I mean, that statute, we have great confidence in it. Any changes that we've made over the previous years obviously has a trickle-down effect to us through the department and procedural and policy. Statutes of limitations would be a perfect example of a review of how 1 year's worth of time, as the General has alluded in examples, that's a pretty wide aperture that can provide us the complexity of a case that makes that timing go out for several hundred days to complete.
Well, certainly what we want to have is a system that we do not have right now, where we can more expeditiously discipline officers in substantiated cases, but not hurt their careers and not hurt the military as a whole on cases that are not substantiated but drag out forever. And so there's really a need, I think, to figure out how we can move this system along faster. Ms. McSally, you're now recognized for 5 minutes.
Thank you, Mr. Chairman. I really appreciate it. I do want to follow up on that. While we do need a process to hold people accountable when they've had wrongdoing, and we need to make sure that there's no dirtbags in senior leadership positions, I know way too many examples of very good people who are caught up in this process, whose names are maligned, who don't have a chance to defend themselves until the investigation is nearly complete. They don't even know what charges are brought against them. In the court of public opinion, they're already guilty. They're not exonerated publicly at all, so they end up, them and their families are held in shame for long periods of time, only to kind of disappear at the end of a long, distinguished career. This process, I mean, I hear and I know of way too many examples of this. And so when we're talking about these processes of sorting out the frivolous complaint, commanders have to make tough decisions. Sometimes they got to clean up organizations. Sometimes people don't like that. Sometimes people have to, be held accountable below them. And we've got to be able to protect legitimate whistleblowers while also protecting due process for the accused. And again, I have way too many examples that bring concern to me about this process, both at the service level and at the DOD level. So a couple of quick questions. We also, I think, have a culture, by the way, that if any of them ask for a lawyer, they must be guilty. But then we have investigators that are acting like prosecutors, and they're not getting the legal advice that they need in order to not be trapped. So I think that's a cultural issue, not necessarily a process issue. How long, if an investigation goes on and somebody's exonerated, how long does that investigation stay on file, and are they kept on file in order to confirm whether that person is confirmable to a higher rank or a new job? Can anybody answer that?
I can answer to the extent that we accumulate with derogatory information, including substantiated findings, and are required to provide that to both the Department and the Senate when someone's up for promotion. We do it if there's a substantiated case. If it's not substantiated, that's not derogatory information.
So unsubstantiated cases are kept on file for how long?
We keep the files. I mean, we don't get rid of the files, but in terms of it doesn't go into the personnel
And are we saying
files.
that there is no process by which they were checking confirmability of any general officers with unsubstantiated cases?
When we have a records check process, and we do that records check, and if it's not substantiated, it does not come up as a positive on that records check.
So it basically says nothing?
We provide, negative information to the department.
Okay, what about the process of an individual who's accused not knowing necessarily what they're accused of until the investigation, in great detail? Again, we've heard from recently this happening, until the investigation's wrapped up, and then they have to defend themselves after a whole package of stuff has been put together, and now they're having to go down all these rabbit holes to figure out how to defend themselves instead of being right up front. And this is an example from the Air Force. General Harris.
We defend our process, which we believe is fair and accurate and thorough. And so we take the time to get the information from our witnesses and the complainants in order to gather all that together. And then at the end, we do absolutely interview the subject so that they do have their time to speak.
Do you see a concern that maybe a accused needs to know up front what they're accused of so that they can in parallel be preparing themselves to defend themselves? Because sometimes these rabbit holes go deep and then you're having to unwind it if you're just handed this package at the end of the whole thing.
Ma'am, I would just say that you have to be very careful because if you start making allegations that you could set this individual up for reprisal. You know, we do a lot of, I mean, DODIG does it, we do it, we do a credibility assessment. In fact, there's a lot of heavy investigative load on the front end as we try to see if this allegation is in fact credible. Credible determination is a big piece. And again, we work with our DODIG brethren up here to make sure that we agree. Okay, so then we'll launch on an investigation. But we want to get some facts together because we also don't want to set this general officer up, oh, hey, you're under investigation for this. Well, if that person happens to be under command and it may be unsubstantiated, then anytime he deals with the person who's making the complaint could set this person up for reprisal. So we're very careful in that respect.
I hear you, but do you understand the concern that I'm conveying? That you guys may go through a very lengthy process and then somebody's just handed the
But once
results.
we determine there's a credible allegation, that person is basically, hey, here's what you're being accused of, and we read him his rights.
And that's the same with us. We have a script that once it's determined to be credible and we are going to investigate, there's a script that we read, and the complaint is as follows: the following rule and regulation has been violated. We tell them do not interview or talk to anybody. So there's a whole script to make sure that they understand exactly what.
You know, I hear what you're saying. Again, the vast majority of these cases are unsubstantiated and frivolous allegations. So I'm talking about the individual who served their country well, who's now being held up for retirement, who's now being moved with their family, wondering what their future is, who's already been tried in the court of public opinion, and in the end, it's unsubstantiated. But them holding on, wondering what their fate is for long periods of time, not getting an ability to defend themselves until it's all over. I mean, it may make you feel better that they're unsubstantiated at the end, but the process that they went through is not a positive one. And that's one I think that really we need to shine a greater light on in order to protect those that are accused who in the end are innocent. Is there any sort of way that they can be publicly exonerated? I know I missed the first round, but I got... Okay. All right. Thank you. I'll wind up and then I'll come back again. If you don't mind, I won't be long, but is there a way for them to be publicly exonerated for something that they didn't commit when this is all over, to at least clear people's names?
One thing we do is we consider our reports for proactive release. If they're substantiated and involve a high-level official, we do not wait for a FOIA request years later, but we will release it. At the same time, if it's already received public attention, if somebody is out there as having been accused of something, we'll consider that for proactive release as well, just so that the result of that investigation can be...
well, there's a difference between being in the media and having an entire unit and everybody who's ever served with somebody hearing all the rumors and innuendos and what's going on as far as the investigation goes. So is there not a way that we can, when somebody is cleared, that you can, regardless of whether it's been in the public eye, say this person is exonerated, or if they request that? Maybe some people don't want that, but...
Well, I think as long as the person agrees, they can go to the public affairs officer and have the say, hey, it was not substantiated. But a lot of people don't realize what's going on unless they've been substantiated. Here's at least in my view, I've seen this for 6.5 years. Yeah. How these things get into the press and how they get in there. I mean, I'm not big into public release, into public shaming. That's just not what I'm into. However, what I believe in is that every 6 months, we have two folks that FOIA give me all the substantiations for all general officers. And we do. We give them a spreadsheet. Here's all the substantiations for all general officers. And then they pick the salacious ones, and then that makes the next headline, the next newspaper. That's how this works. So they all get out there. All the salacious ones get out there.
Yeah, I'm talking about the unsubstantiated ones.
I know exactly what you're talking about, but I'm just saying that most people, if they're not substantiated, don't want it out there because they're under investigation because most people don't know.
I hear you. Can you talk about the process of what investigations are done by the services and which investigations are done by the DODIG, really briefly? I see in your testimony it says normally 3 and 4 stars are at DODIG level, or something that's of such a high level of attention. But is there other determinations on that? And if the services actually close an investigation and unsubstantiate it, do we have cases where the DODIG decides to open it up again or take it on after the fact?
So on the front end, we do the 3-star and 4-star, the SES employees, presidential appointees, intelligence-type investigations. And if there's a conflict or some reason why the service IG shouldn't do it or can't do it, we'll do those as well. Otherwise, they do the investigation. When it is completed, they provide it to us for oversight. If we think it's thorough and has done all the investigatory work that needs to be done, we approve it. If we don't, we can send it back to them for additional work.
So is there ever cases where you then take on an investigation yourself after they've closed it?
There's been occasion, yeah.
Okay.
Yeah, for
How
a
often does that
good
happen?
reason, very rarely.
Okay.
For additional information or for some specific reason, but it's happened.
Okay, thanks. I yield back.
Ms. Spear.
Thank you, Mr. Chairman. I just want to make something really clear from my perspective. I think we do have a problem with different spanks for different ranks. As I understand it, there have been 70,000 court-martials in the Air Force, for instance, and not one general officer has ever been court-martialed. When some of my colleagues were talking about the UCMJ and how, if what the UCMJ does is provide for accountability where there wouldn't be, where this isn't criminal conduct, there are cases that have just been brought to my attention. For instance, Lieutenant General Ron Lewis, who misused government credit cards at 2 strip clubs, falsely claimed his credit cards had been stolen, fraudulently stole over $1,000 from credit card company, violated an order by going to restricted area, and had an inappropriate relationship. He didn't get prosecuted under the UCMJ. He didn't have a court-martial. A junior enlisted would get prosecuted for that offense. General Kip Ward, misuse of government resources for his personal gain and his family, was ordered to pay back $82,000. That's theft. And under normal circumstances, that would be subject to a court-martial. So as we look at this issue, I think one of the things that I would like to see, Mr. Chairman, is that we take the time to make sure that everyone is being treated fairly in the military. I'd really appreciate having from each of the services the number of court-martials, how many for enlisted, how many for officers, so we can just take a look at that as well. And let me also point out to you that yesterday we passed a very strong sexual harassment bill in the House. There have been a number of members who've resigned or are retiring as a result of sexual harassment, not sexual assault here. And I think that as we look at the military, we're going to expect the same level of responsibility for conduct that we are now expecting of members of Congress. Yield back. Thank you.
We'll now take a brief recess in order to set the witness table for the second panel. We'll take a 5-minute recess. I wish now to welcome our esteemed second panel. We would like to respectfully remind the second panel to summarize to the greatest extent possible the high points of your written testimony in 5 minutes or less. Your written comments and statements will be made part of the record. Our second panel consists of General James C. McConville, Vice Chief of Staff of the Army, Admiral Bill Morin, Vice Chief of Naval Operations, General Stephen W. Wilson, Vice Chief of Staff of the Air Force, General Glenn M. Walters, Assistant Commandant of the Marine Corps. With that, General McConville, you may now make your opening statement.
Well, thank you, sir. Chairman Kaufman, Ranking Member Speer, distinguished members of the subcommittee, good morning. Thank you for the opportunity to testify today. The United States military is one of the most trusted institutions in the country, and we value that bond of trust, and we recognize that every single day we need to wake up and earn that trust. While senior misconduct in the Army is down 51%, we know that one act of misconduct breaks that trust with the American people. Senior misconduct in the United States Army has no place. Our senior officers are developed through decades of formal and informal training on ethics, Army values, leadership, and character. And we provide additional training for those leaders when they're selected to serve as general officers. The vast majority of our senior officers uphold our demanding moral and ethical standards, just as we, their soldiers, and the American people expect them to. We're not a perfect institution, but we strive to be one. Senior officers who fail to meet the Army standards are held accountable. I, along with the other Army leaders, are committed to upholding the standards of our profession and to ensuring all our senior officers do the same. I appreciate your time and attention this morning and look forward to your questions.
Mr. Chairman, Ranking Member Speer, thank you for the opportunity to be here to speak to subcommittee members, the American public, but most importantly this morning, to talk to our sailors. The foundation of our joint force, and this is going to sound like a broken record, and just demonstrates how much we believe in the values of our institution. But the foundation of the joint force is trust. When senior leaders fail, trust at the institution level is put at risk, which can have a profound impact on every aspect of developing and employing this force. So we all take this topic extremely seriously. And while we all seem to be trending in the right direction, as Jim just articulated, every single one of these matters. At the end of the day, we are an institution comprised of human beings who are indeed fallible. So to get after this, we have taken deliberate steps to train and develop our enlisted and officer corps throughout their careers to preclude moral and ethical failures. And when they do fail, we address them in ways to preserve the larger trust in the institution. Being transparent and accountable is part of this effort. Our goal is by the time senior leaders are produced, they have a solid foundation formed through years of experience where the principles of ethical behavior and moral decision-making and proper professional conduct are not only taught, but reinforced and tested. As you've heard from our Inspector General, we not only routinely track the data, we look for trends. When we see evidence, we explore and derive lessons learned to be better leaders. And while we have ethical guidelines and even rules to limit the consequences of poor decision-making, the rules alone are not what you and the American public expect from us. You expect us to live up to higher standards of professional behavior. Transparency along these lines is central to our efforts to strengthen trust within our ranks, within the institution, with the American public, and I believe it strengthens our relationship with Congress. So thank you for the opportunity to be transparent today, to speak candidly and directly about this critical topic, because it's the foundation of our profession. Thank you very much.
Chairman Kaufman, Ranking Member Speer, distinguished members of the subcommittee, thank you for inviting me to testify before you today. On behalf of our Secretary of the Air Force and our Chief of Staff and the 670,000 total force airmen around the globe, it's an honor to be here, and it's an honor to be here with my Vice Chiefs. Late last summer, on the eve of our 70th birthday as a nation, as a service, I had the privilege to stand a few miles from here on the turf of National Ballpark. 46 of America's sons and daughters were in front of me, the backdrop of the Capitol behind them. They were about to enter the United States Air Force. In that moment, I thought about what we owe those patriotic volunteers in return for their selfless service and their selflessness. The word that came to mind was trust. I think all of us Vice Chiefs view maintaining trust and confidence with the American people and with our force as the essential element of our past and future mission success. It's for that reason that we employ a deliberate and career-long continuum of learning, not only in operations and leadership, but in law and ethical standards for all airmen and certainly for our senior officers. Despite those efforts, at times senior officers do break bonds of trust by faltering in judgment and/or character. And in those instances, we leverage a robust system of investigation and accountability. Complaints are investigated by independent teams of professionals. Disposition is done with objectivity, steeped in process and law. I know I can speak for my fellow chiefs here. Even one case of senior officer misconduct is too many. Our goal is for all airmen to do what's right at all times, regardless of the circumstances, and no matter the rank or the position. If they fall short of that goal, we will hold them accountable for their actions. Thank you for your continued leadership and your partnership as we seek to achieve that goal and, by extension, maintain the trust of all airmen and the American people. I look forward to your questions.
Chairman Kaufman, Ranking Member Speer, and distinguished members of the House Armed Services Subcommittee, thank you for the opportunity to appear here today and report to you on this very important issue, the moral and ethical conduct of our Marine general officers. We know that our nation's citizens expect the very best from their Marines. They expect operational excellence. They trust that their Marines are women and men of the highest character, both on the battlefield and in every aspect of their lives. We Marines expect the same from ourselves. We readily accept this responsibility. Our core values of honor, courage, and commitment guide our moral and ethical conduct of every Marine. All Marines are custodians of these core values. Our senior leaders set the example for every Marine to emulate. They understand this responsibility, and they spend their lives upholding these values. They understand that winning our nation's battles requires a foundation of character within every Marine, and it starts with them. Marines learn these sacred values early and often. We believe that through our continuum of training throughout an officer's career and oversight and education, provided by our inspection programs, we build ethical decision makers. At every level of officer training and education, we continually and consistently emphasize ethical leadership as the foundation of leading Marines. Over the last 10 years, the Marines have averaged 1.5 cases per year of substantiated general officer misconduct. In nearly half these cases, the mistakes have been administrative in nature. While we take pride in the moral conduct of our generals, we acknowledge that there is always room to improve. Like every improving and learning organization, we remain proactive to evolving our education, training, and programs to ensure the disciplined moral conduct of every Marine, especially our general officers. On behalf of our Commandant, General Robert Neller, we thank the Congress and this subcommittee for the opportunity to discuss this important issue. We appreciate your continued support to ensure the Joint Force remains the very best military our nation requires and expects. And I look forward to your questions.
Let me ask this question and appreciate an answer from the Army, Navy, then the Air Force, and then the Marine Corps. Many of us are familiar with the consequences of a court-martial conviction, but less familiar with some of the other administrative and non-judicial actions that can be taken against service members. Could you explain the other options available to you when disposing of senior leader misconduct cases and the consequences thereof? General McConville.
Yes, sir, I could. What's at us disposal if we don't go to a court-martial is we could do a memorandum of concern, a memorandum of reprimand, but what really hurts an officer is a general officer memorandum of reprimand that we put in their official file. And that goes in the official file. It basically ends their career as they go forward. And then as they go to retire, that is seen by the board that adjudicates what rank they'll retire at. So basically, that you could lose 1, 2, 3 stars depending on what rank you retire at, which is hundreds of thousands of dollars for some type of misconduct at that level.
Yes, sir. I was going to mention the retirement grade determination process that all of us go through for any flag officer, senior leader who has had a substantiated allegation that what we term becomes adverse information to their record. We must do a board, and we all do that. We carry out that process. A retirement grade determination for 1 and 2 stars is ultimately signed off by senior leaders in the Navy on all of our services would be at secretary level. And for a 3 or 4 star retirement grade determination must be approved by the Secretary of Defense.
Let me fully understand this. So that you give some sort of letter of admonition or whatever that's there. So it's a career killer. So that person is not going to get promoted. They may be able to finish out their tour of duty or at some level, I suppose, be able to finish their career. So then they go to retirement, and then they're reviewed by a board to determine whether or not they're going to be reduced in rank in retirement. Am I clear on that?
If it's adverse information, yes, sir. And I would add, I won't speak for the rest of the services here, but for the Navy, if a senior officer is found with substantiated allegations that are serious, they're not asked to, they will not stay for the rest of their tour. They're often relieved of their command, relieved of their duties, and asked to retire. And then we go through the retirement grade determination.
Okay. So somebody that you were going to allow to finish their, it was a letter of admonition. It's a career killer, but you're going to let them finish their tour of duty.
Not necessarily.
So
if it's serious enough for a letter of admonition, then they're not going to continue.
They're not going to. Okay,
Yes,
General Wilson.
We have the same process, so ours would be a letter of reprimand or an Article 15 type of instance, and the same things would apply. We would determine whether or not they should still serve in that job. In most cases, for a senior officer, if they've got an Article 15 or a letter of reprimand, they're going to be removed from that job immediately, and they'll go through an officer grade determination to follow.
So, and effectively, if somebody got a letter of admonition, forced to retire, reduced in rank in that retirement, it's literally the equivalent of a fine of hundreds of thousands of dollars. Am I correct?
That's correct.
Okay. General Walters?
Sir, we follow the same process. The one example I could give you, albeit it's 10 years old, we had a selected 2-star. He had a substantiated finding on him. He was retired as an 06.
Wow.
So he didn't get a 2nd star. He retired as an 06, and I actually did the calculation last night. And if you compare his 06 retirement to an 08 retirement, what he really lost in compensation over a 30-year retirement is $1.9 million.
Okay. Yeah. Ms. Spear.
Thank you all for your presentations, for your conversations yesterday. I guess this question can be asked of you as well. Could you inform us by letter of how many court-martials there have been of general officers? The chairman just talked about the potential of loss of rank and loss of hundreds of thousands of dollars over one's lifetime in retirement, although they still keep their retirement. I'm more interested in the value of a security clearance, because that's worth a lot of money, a whole lot more money than $200,000, frankly. And in some cases, these cases that have come before us where they have lied and done things that you would, question their moral turpitude, drunkenness. Under normal circumstances, someone could, in fact, lose their security clearance. But I wonder how many do lose their security clearance. Does anyone have any thoughts on that? And if you don't, if you could also provide that to us for the record of these cases that have we've seen so much prominence, and we can provide them to you if you don't know them off the top of your heads. I'd be curious to know how many actually lose their security clearance, because that's more valuable, I think, than many other things. Admiral, you talked about transparency in your opening remarks, and I think that that is really important from the congressional oversight perspective. The DODIG does disclose substantiated cases, but to my knowledge, there isn't any means by which each of your services would disclose to Congress, for instance, substantiated cases. Could you, each of you, inform us as to whether or not you would be supportive of that?
As far as the Army, if this committee wants those cases, absolutely.
Thank you.
Yes, ma'am.
Yes, ma'am.
No problem, ma'am.
All right. Thank you. Admiral, the Fat Leonard case has come up a number of times, and it is probably the most egregious case in the history, certainly of the Navy, if not the military in general. Because so many people were involved and so many people corrupted by this individual, I'm stunned that there weren't any bystanders that spoke up. First question, how did it actually, there were a number of cases that were investigated by NCIS because there was bid rigging or overcharging for fuel or the like that he was engaged in. But many of those cases were just missed. Have you done kind of a post-mortem on that to look at where the holes were within the chain of command in terms of identifying the issues and addressing them?
Ma'am, I hope you'll respect this comment. It is an ongoing federal investigation by the Department of Justice and the U.S. Attorney. I'm very uncomfortable answering questions that could prejudice the case in any way, and so answering some of that, what you just asked, could potentially cause us problems. And when it is done, and we're hopefully getting to the very end of this now, when it is done and all the files are turned over to us, we will do that. And there's a process in place to make sure that we evaluate every single case that comes to the Navy. Whether they're handled by the Department of Justice or not, they come to us for final resolution. And we cannot talk publicly about that until the Department of Justice is complete with their investigation.
No, I appreciate that, and I'm not asking you to do that. But from a policy standpoint, are there any new policies that you recognize would be helpful in preventing cases like this from, exploding into scandals that are of proportions that it's hard to even comprehend?
Yeah, most of the issues revolve around the contracting for services in overseas ports. So we have taken a very strong turn on the process by which we do that. We put layers of oversight into how those contracts are issued and who is issuing them. And that sort of training in our supply corps and in our general support corps has been very strong over the last 5 years. And we think that largely has helped us drive down the number of misconduct cases that have resulted outside the scope of the GDMA case.
One last question. Bystanders. Do you think bystanders have a duty to report? Question for each of you.
Absolutely.
In every single case. We talk a lot about this in sexual harassment training, sexual assault, but all what we would call behaviors that are destructive in nature. Oftentimes it can be quelled by a bystander, and we try to teach that value to everyone.
Completely agree.
Yes, ma'am. We teach, see something, say something.
Okay. Thank you.
Mr. Bacon, you're now recognized for 5 minutes.
Thank you very much. I appreciate all of you being here and your leadership. I would like to just go back to a question I asked in the previous panel about the different spanks for different ranks. Do you think we're holding people equally accountable in your view, whether it's a mid-level senior NCO to a senior officer? Thank you.
I do my previous, I was Commanding General of the 101st Airborne Division for 3 years, had General Court-Martial authority, handled a lot of the cases at the lower level, and now as the Vice Chief of Staff of the Army for the last 7.5 months, I believe we hold everyone appropriately accountable. And when we look at senior officers, we expect our higher standard from them, and when they don't meet the standards, we hold them accountable.
Thank you. Admiral Moran?
Yes, sir. Both Jim and I served as prior ones, which are our personnel commands, and in every disciplinary case, every single one that reaches the level of where we're trying to determine if someone should be retired early or retired without pay or so on and so forth, or released from active duty. We see every one of those packages, and as vice chiefs, we see them again. And so I think we get to see across the board a pretty balanced view of senior and junior cases. And I think we all also believe that if we do not do this in a fair way, we're going to be held accountable by our sailors, soldiers, airmen, and Marines. So I think we're very conscious of doing this in a correct way.
Thank you, Admiral. General Wilson.
Yeah, Congressman Bacon, I completely agree with my counterparts here that we hold all of our airmen to one standard. And I would also add, though, that we hold our senior officers to an exceptionally high standard, that we know that we'll be judged by that. And so that in my time as a vice chief, I've seen that we're not going to walk by any problem, that we're going to hold any senior officer who does any misconduct accountable for that. We're going to investigate it and then hold them accountable.
Thank you. Joe Walters.
Yes, sir. I agree with all my counterparts here. I'll just add one thing is to remember that our senior officers, one shot and you're adjudicated, one shot and you're down, perhaps, whereas on some of the junior ranks, second chance. It's not a zero defect mentality. I would say it's almost a zero defect mentality the higher up you go.
I know I appreciated second chances when I was 18 and 19.
Yes, sir. Me too.
Wanted to just sort of pose a rough hypothetical, and whoever wants to speak up on it. I think part of the issue is if you have someone who's served honorably for 30 years, say they're a 1 or 2 star at that point, and then you're 31 and 32 as a 3-star, maybe involved in a professional relationship or whatever it may be, and then you have to determine at retirement, do you go back to the 2-star or 1-star versus someone, say, at the 8-year point, and they do something similar. How hard is that from your perspective to determine? Is going back ranked to the 30-year point, or should it even be more serious depending on the crime or action taken? How hard is that when you're making these determinations, I guess? Because my point being is sometimes we go back to the last rank honorably served, but yet if it's a junior enlisted or something, that maybe they suffer career-ending decision there. So I'd just be curious for your insights.
Perhaps I could illuminate a little bit, sir. The great determination is a process that is in place for all of us. But the reminder is, I don't care if it's a junior Marine or senior Marine, if the action is criminal, then there's no rank involved. I can name, we've had one in the last 5 years where it was a senior officer in 06, and he's 0.
And they would retire with no rank. Or
he gets no retirement. He's in jail, and he's 0. He's got no rank at all.
Any other comments?
I'll follow along with the comments. I agree. There's a difference. We've had 2 court martials, and one I won't talk about right now, but that have been adjudicated over the last 10 years. And both officers were of criminal type nature, and we will court martial them if they warrant that. But when it looks at, we weigh every single case on its merits. We look at what the soldier or the officer's done over the many years, and we weigh all that, and we put it together, and we try to do the right thing when it comes to making a decision on their future.
Chairman, I yield back.
Ms. McSally, you're now recognized for 5 minutes.
Thank you, Mr. Chairman. I want to follow up on my previous line of questioning. How long are unsubstantiated reports kept in each of your services? Do you know?
Maybe I'll start. Are we talking just senior officers, ma'am?
Yeah.
Yeah. So we have other terms when we talk about investigations where there are substantiations and then there are unsubstantiated but reportable information. Reportable meaning that it wasn't adverse, but is still required by the Senate for confirmation. So it's a little bit different from.
Okay, and what's an example of something that's unsubstantiated but reportable?
Well, let's say someone was accused of something. Boy, there's so many of these are fresh in my mind from a topic I'm not at liberty to talk about. But if it was you were alleged to have gone to a dinner with a contractor and accepted that dinner, and it was unsubstantiated that it was accepted, by you, but it was alleged to be that you had you did attend a dinner with a contractor. That can be reportable, but not.
So with people that are going through an entire investigative process, they are cleared, but yet in a nomination, even though they're cleared, it's reportable to the Senate for their confirmation?
The Senate is entitled to any information on an officer being considered for promotion to the rank of 07 and above.
Okay, that was kind of my line of questioning in the last session, but it seemed like all the panelists said that unsubstantiated claims are never taken into account for jobs or rank. And so now I'm hearing that they are. Even unsubstantiated claims are taken into account.
They have to be accounted for. That doesn't mean that will prevent them from being promoted. It just means we have to.
So within the services, I don't know if each of you could answer, is there anywhere informally or formally in your process of considering someone for a new job or rank where you actually look at unsubstantiated investigations as part of that process?
Well, one of the things that we look at is titling. If there's when we look at vetting an officer, we look at all the databases that come up to see where that. And I'll give you an example. This did not hold up the officer, but the officer was titled because his dog got loose in the neighborhood. So the MPs came by, they titled him for having a loose dog in the neighborhood, and he was, actually he was, substantiated for having the dog loose in the neighborhood. So that.
Yeah, I'm talking about where people are cleared, and are they somehow in any informal or formal process? Are people looking at the files of their cleared allegations and cleared investigation as to whether they're going to offer them for a new job or promotion? You see what I'm trying to get to the core of here?
Yeah.
Is you're innocent?
We don't do that.
Okay, thanks, Debbie. Oh, General Wilson, sorry. General Walters?
No, I mean, we were required to report all the information that a confirmation the Senate.
So all information includes unsubstantiated claims?
You have to report whether they were investigated in some cases, and these are the rules that are set. We don't have a big stack of in my office, of all the unsubstantiated. I don't have any of those. That's really the legal review. And they know what parameters that the Senate requires that goes in with a confirmation package. I sign off all those. And it's usually a paragraph at the bottom that says something along the lines of, we've looked at OGD 278, we've looked at this, and no substantiations, but there is a entry in here. And that's all it'll be. And then it'll be up to the Senate to say, tell me more if they're interested.
So Congressman, you will remember a non-punitive letter in your days where that's between the commander and the individual, not to be for anyone else.
Yeah.
That is required. A non-punitive letter for a flag officer or a nominee for flag is required by the Senate to be reported.
Okay. But are you saying it's the current law, like we have in the law, that if I'm talking about IG investigations that are closed and somebody has been exonerated, that they still, even though they're innocent, just because they were accused, that has to be reported to the Senate?
No, ma'am. That's not what I'm saying. I'm saying that if something was issued to an officer that's up for promotion to flag, unlike for the rest of the service, anyone else with a non-punitive, that is no one else's business. Those are still required to be brought forward.
Okay, so it still goes back to my question is, and there anywhere in the process within the services that, I know we've heard from General Wilson, that unsubstantiated investigations are looked at, formally or informally, by the services, whether you're considering somebody for a new job or promotion?
In the promotion boards, if it's not adverse information, it's not examined during the promotion board.
I'm not talking about a promotion board. I'm talking about as you all sit around talking about who's going to be put into this next job or be considered for the next star.
As we're looking at a slate, I think that's what you're talking about, is we do a slate up, and we do slates continuing through the year because things change and demand signals on people change. I can't remember anybody, well, it's only two of us, the Commandant and I, saying, well, there's an unsubstantiated claim. That never comes up.
Okay, I'm over my time.
Sure.
I don't know if you guys get what I'm trying to get at, but accused doesn't mean guilty, and I just want to make sure that that's not being taken into consideration.
Dr. Wenstrup, you're now recognized for 5 minutes.
Thank you. I have a question, something that I think I'm seeing a rise in, and it's not at the same level of some of the cases we've been talking about today. But you have not general officers, but officers that have the responsibility of making sure that their troops are doing the things they're supposed to do. And I've become aware of a couple cases where the lower ranking person, either officer or enlisted, wants to resist that. And all the leader's doing is saying, listen, you got to be in line, you got to get your job done. Then they go, the person not doing their job, go and accuse some kind of bias, that this leader has some kind of bias. And what I'm seeing is these leaders then, they're now the accused of something just because they were trying to make sure someone did their job. They make this claim of some kind of bias, and now that leader is tied up in knots, distracted from doing the job they're supposed to do every day because they have to defend themselves, and we're losing good people. Because they get to the point where it's like, I want out. I don't need this harassment when all I'm trying to do is do what's right. And you're all shaking your heads like, I'm familiar with this type of antics taking place. How do we empower? I'm not saying that there can't be leaders that are out of line. Don't get me wrong. But how do we defend the people that are getting tied up in knots and kept from doing their job in leadership because somebody who's not doing their job decides they're going to take that route? And are you seeing a rise in this type of
well, we're certainly, I think I can speak for our service, very, very concerned about those type issues. We want commanders not to be looking over their shoulders when they're making decisions. On the other hand, we want to make sure that, our soldiers have access, if they see something wrong, to come forward. And it really becomes trying to find that sweet spot in between. And we have to watch that as we go forward. And you heard IG talk about that, kind of concerned about how maybe some people are taking advantage of that. And we just have to watch that. We have to come back. And there's things we can do when we look at some of the cases. Some of them may be triage up front. We take a look at it. And there's risk in that because the best thing to do is do a 400 or 500 day investigation. You'll be absolutely sure that you have no issues probably at the end. On the other hand, you may hold up someone at retirement or something like that, and I'm not sure that's fair either. So we're trying to find the best way to make this fair for both involved.
I would like to see some focus on speeding up that process because I'm seeing some good people get dragged through the mud for absolutely no good reason whatsoever, just because you told someone they need to get their OER done. I mean, that is a little bit ridiculous. And then they start saying you're picking on me. So obviously I'm speaking from a real experience, and I'd love to hear from more of you.
Sir, I think what we're talking, we have a process, and we want whistleblowers to have the option to come forward and tell us when wrong things are being done. But that process right now, the reprisal process, is broad-ranging. We have a thing called request masked. Administrative errors, any young Marine can go all the way up the chain of command to get whatever he believes or she believes is an error corrected. But what I think we're seeing a trend in, instead of using that request mask because they got to go talk to the commander, then the commander's commander, and off the chain, instead of doing that, they just pick up the phone and make a complaint on a hotline for an administrative error. They didn't get the award they didn't think their fitness report was accurate, or they didn't get the leave they wanted, or they got declined on leave. So these are administrative in nature, and we have the request mask process to adjudicate those and accommodate those, and it allows leaders to fix things when they're broken. As soon as they pick up the phone for those kinds of issues, it goes into a different process, which, as you pointed out, can take too long.
By the way, it's not me involved with one of those. It's an outside observer. Go ahead.
We think we're a little bit out of balance on the whistleblower reprisal piece. About 96% of the cases are not substantiated. So it would tell you that we're spending a lot of time, and yet what's not in balance. And to your point, that has a chilling effect not only on the commanders but on the force when they can't when we're trying to execute good order and discipline, and you feel this cloud above you. And we completely agree that if somebody is going to be investigated, it should be done in a timely manner. And if they're found guilty, then let's move on with that. If not, they should be also on the innocent side, remove that quickly. It's taken way too long.
Thank you.
Yeah, I agree. The timeliness is the issue here, to your point, sir. Yeah. And when we can get better at that, I think it'll help resolve a lot of this. But we are spending the same amount of time on very few cases that are ultimately substantiated.
Thank you. Yield back.
Mr. Russell, you're now recognized for 5 minutes.
Thank you, Mr. Chairman, and thank each of you for being here today. I guess a lot of the statistics that we see amalgamated together include military misconduct, what would be clearly viewed as potential misconduct, but may not be translatable in the civilian world. But it also includes a wide array of tools that are used to address that misconduct, and all of that gets rolled up into this statistical analysis. And so I guess my question would be, what percent of the cases that we see, and some of the statistics I've looked at, it's like, okay, so maybe 10% of the cases warrant further investigation, so 90% kind of thrown out. Of the 10% that are there, roughly 30% of those end up being substantiated. I mean, those are rough figures, but seems to be some consistency there. So we're still talking small percentages. But even among that portion, not all of those are for like the big headline cases that we see. A lot of them could be, you moved a boat with your household goods when you shouldn't have, or something. Would you speak to that? What percent of the cases would never translate into offenses in civilian employment?
Well, I'll start, I guess. It's really hard to say since I graduated from high school. I've had a uniform on, so I don't really know. I'll try to get that answer for you and put it in writing, but I wish I could tell you. All I know is the standards we have.
Well, I mean, there are some things, just like with a sailor, I mean, he's swabbing the deck, or a soldier buffing the floors or whatever over something that would never, they would never have anything entered in any record or file. There would never be any offense. And I know that also can apply to general officers on certain standards of conduct that the military expects and demands, certainly of our senior leaders, but yet if they were in the corporate world, this would not be anything that would translate. And yet that's still part of the statistical body, and that's what I'm trying to get at, and whoever would like to address that.
Well, we've had things from officer evaluation reports being late because the commander was waiting on a discipline issue before he actually wrote the OER. So technically, he was substantiated for a late OER because he was just waiting for this thing to resolve. Of course, we didn't, it didn't ruin his career, but he did go through a process which delayed him, and it runs all the way to an inappropriate relationship. And even on the civilian side, if you had an inappropriate relationship, or inappropriate consensual relationship, sure, we hold people very accountable for those type things. If you went to a gentleman's club, on the civilian, but we hold people very accountable for those type things, and I think we should have a high standard in the military.
General Wilson.
Looked at over the last 5 years, we've had 77 cases. As we've looked at that, about 60% of them I'm going to call an error in judgment and administrative procedures. About 25% of those involve personnel matters, and those that involve some type of sexual harassment or inappropriate relationship was under 15%.
Thank you. General Walters.
Sir, I'm looking at, so in the last 10 years we've had 15 in our general officers. And I was looking at them, most of them are admin. They wouldn't be taken, held accountable out in the government. I had one TAD where he got extra money on his TD claim. I guess that's theft, and that could be chargeable. Out in the civilian world, we took care of it, and I think it was $10, and we made him cut a check, and then we reprimanded him.
Well, and I appreciate that. And Mr. Chairman, that's part of what I'm just trying to establish is that a lot of the statistics are rolled in to where it looks like a greater problem of misconduct. And then my final question for Admiral Moran would be, we have heard mention in both panels today the Fat Leonard case and some things like that. But when a case comes up like that has translated over to the Justice Department, is the military limited in how it can even comment or even defend or maybe portray the other side of the story while it's in the Justice Department and outside of Department of Defense?
Yes, sir. We absolutely are. So I look forward to the day when I can come back to this committee and testify about what we've learned from that and and about the things we've put in place to address it. And that's much where I was going with Congresswoman McSally's question. I'm very focused on that right now, and it's hard to talk about it. And some of those cases where they go through a justice review and end up in a Navy review and all are ultimately unsubstantiated after years of investigation are really tough to account for. But Congress now expects us, Senate expects us to address that, even though they were unsubstantiated, just so they know we've looked thoroughly at it. That was my point.
And I think that's important to note, Mr. Chairman, because many times what might be the appearance of that they're trying to hide or harbor information, the reality is when it translates from Department of Defense over to Department of Justice, they are prohibited from providing perhaps very illuminating or alternative views, but yet they can't. And so I think that's very important to establish in the hearing today. And with that,
Ranking Member Spear.
In conversations with one of you, I guess it was over someone being reprimanded for endorsement, it came up that general officers could have outside employment. And then we checked the UCMJ and found out there is no prohibition for general officers to have outside employment, which I think is pretty stunning. Would you approve of us passing an amendment that would prohibit outside of employment?
I certainly would. I don't know what general officer has time to have outside employment. I'd like to know who the person was.
Yeah, I want his job.
Yeah, if he's in the Army, I'll get a new job from him. Okay.
Ma'am, we'll go back and look at the statutes, but I want to believe that we are prohibited from outside employment. We are not prohibited from serving on certain organizations that are for the benefit of the military services that are volunteer organizations as a board member or a contributor to that. But generally speaking, we've been prohibited for as long as I can remember.
I agree with my colleagues.
All right.
No, ma'am. I only experienced it once. I was invited to be a member of a board for Heroes Flight, and my counsel said you can't, and it was gratis, so I didn't have the time anyway.
General Wilson, I'm going to ask you just to write me a memo on this, but to have 70,000 court-martials in the Air Force and never once a court-martial of an officer suggests that maybe there's something to that. So I would just like you to write me a memo to give me some of your thoughts on that. The UCMJ also has a statute of limitations that in many cases is less than it would be in the civilian world. For instance, for bribery, UCMJ has a 5-year statute of limitations. In the general society, it can be up 7 to 10 years. Would you look at the statute of limitations for various forms of conduct in the military and give us your recommendations as to which ones should be increased? And then finally, General Walters, this was in the paper today, in case you haven't seen it.
Is that USA Today, ma'am?
Yes, it's Marine Corps brushed off sex charges. It's and what's stunning about this particular case is that you have 2 women who have been sexually harassed by the same person, and nothing happened. And when the one survivor of the sexual harassment went to her superior, they said, "No one will believe you." And if you've heard anything from the members of Congress over the last few months is, we believe the women. So I hope that this becomes an anomaly as we continue to evolve in terms of the issue of sexual harassment. I think we have a huge problem. We have a huge problem in our academies, and I think we have a huge problem in our services. That isn't even getting to the issue of sexual assault. That's the issue of sexual harassment. And I think we've got to do something dramatic to shift the culture. And with that, Mr. Chairman, I yield back.
Ms. McSally, you're now recognized.
Thank you. As we've talked about in both panels, we've got probably an issue with reprisal whistleblower maybe being overly utilized, and legitimate cases obviously need to be addressed and people need to be held accountable, but the system is being bogged down with a lot of other cases. And in some cases, as we all know, people maybe it's their situational awareness is low and their perception of reality is such that they're reporting what they believe to be wrongdoing that you all unsubstantiate. But in some cases, somebody may be fraudulently claiming wrongdoing of someone above them, and you'll investigate that. Again, assuming the person has been exonerated, has there ever been examples of going back and the accused being looked at for false claims or fraudulent claims or lying to investigators or anything like that in those cases? No examples of that?
I'm not aware of any.
Is there a process even to take a look at that somewhere along the line?
I would put that under the heading of you don't want to put anything out there that will preclude someone from coming forward in the future.
Totally agree.
Good one.
However, if somebody has brought together a false allegation.
If they truly believed in their allegation, although it proved to be false, I still don't think, and it turned out not to be true. I don't think there's. And
my bet would be that'd be the vast majority of cases,
right.
But there may be a rare case within the process that you need to take a look at whether their own conduct is the issue. Yeah. Is there any sort of process there to even take a look at that, whether somebody lied or has a fraudulent claim or anything like that? Everybody deserves due process.
I'm told there is a process, but can we get back to you with a written answer response to that to give you more detail behind it?
Great. And I don't know if you all can answer this versus the IGs on the first panel, but what sort of training do the investigators go through, and is there any sort of review to ensure that they don't take a prosecutorial mindset of, rewarding getting some kills versus fact-finding and just sort of oversight of the investigator selection and processes?
I think that's another one we can get back to you on, Congresswoman, but there have been perceptions of that in the past, and I know that I've personally had discussions with the gent sitting behind me in our IG chair, and when we see that, he normally addresses it in his command, and I trust that he'll take appropriate action if there is any evidence of that.
Any other comments on that?
No, I agree. I think it's just, same thing with IG. That's why we have a lot of checks and balances in the system, both on the legal side and the command side. It's not, at least from where we sit, it's not arbitrary as how these decisions are made, and that's why they take some time, because they are reviewed at every single level to make sure we don't have things like that happening.
Anyone else?
I just think all the IGs would say that they spend a lot of time on making sure their investigators are trained right and trained appropriately. There are probably cases where that's happened, overzealous investigators before, but I know all of us are emphasizing with our IGs the importance of the training and doing it right.
John Walters?
Always have to be on the outlook for that, ma'am.
Thanks. Would you all support, I mentioned on the first panel, if someone who's exonerated wanted there to be a public statement made that they were exonerated, would you support a process that you all did that? Not them, but you all did that?
I would be glad to do it.
Same.
Yes, ma'am.
Is that something we have to do, or is that something you could do within your own procedures to allow that option if they want you to make a statement that they've been cleared?
Let's look at the procedures, ma'am. I mean, my sense is, much like the IGs told you, that once it's over, most members who are exonerated just want it to be done. They don't want to.
But if somebody would want that to be publicly,
I don't see why we would.
Can you all get back to me as to whether that's internal or whether that's something we need to do? Great, thanks. I yield back.
Mr. Russell, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I just one comment on the outside employment, unless something has changed. Officers in all the services are prohibited from doing outside employment. The exception, probably back to the time we've been wearing tricorn hats, was they could write for publication, and they could, if you had some particular person whose wartime memoirs or experiences were needing to be captured or published. You know, I think of people like General Marshall and others. People wanted to know, and they were allowed to publish their memoirs or do things of that nature. I'm not sure that, Mr. Chairman, a bill would be needed. I think all of that is currently in place. And then we also don't want to put prohibitions on our Guard and Reserve flag officers. My goodness, they wouldn't be able to eat and feed their families. And, if any of you cared to comment on it, that's fine. But General Walters, you didn't have a chance to reply to, you know, I mean, we're accustomed in Congress to often getting headlines that we don't deserve or that maybe we do. But would you care to comment on the headline that was presented earlier?
No, sir. I mean, it was brought to our attention on Monday night. I know the reporter asked for some information. We couldn't turn the FOIA information and redacted PAI fast enough for him before he published. We have our lawyers are looking at it, and they're actually with the complainant right now working out the mitigation plan. So we're looking deep into it. I don't know all the facts yet, but I will find all the facts.
Will the gentleman yield?
Of course.
This is a case that dates back to 2013.
Yes,
and
ma'am.
then 2017.
I think 2013 was in the actions. What I was briefed in last night, 2013 were the actions. The complaint came in, and I think, I believe, I don't know, but I believe that mitigation was put in place, but the mitigation broke down, and now we have to go look at mitigation again.
Well, there was a second woman who then came
right,
forward.
so that and that one never reported, so but now she has. So we have to look at it. Well, one of the problems is getting people to report and having trust in the system. And we've seen the increase in reporting, and we have established through the task force. I'll take this opportunity to offer a full brief on all we've done since last year.
I don't want to take the gentleman's time, so.
And reclaiming the time, and I think the gentle lady, and it is important we establish those trusts and that we do those things. And I think, Mr. Chairman, you know, with your leadership, we've seen from our Service Academy superintendents and commandants that have come and provided us testimony that many times there's a very good process. And when you know, mention was made on some of that, that there being a big problem, I would disagree. I think our hearings here have substantiated that while there are issues that certainly must swiftly be dealt with, when compared to collegiate America, my goodness, you know, colleges would love to have the problems that our academies have in terms of virtually nil in statistics. Now, it doesn't mean that the things that happen there, they have to be swiftly dealt with to the fullest extent of the Uniform Code and also law in criminal cases. But I think that those hearings have been very, very helpful. And thank you for your response, General Walters, on that. And being a true conservative, I'll even give back some time, Mr. Chairman.
I wish to thank all the witnesses for their testimony this morning. Senior leader misconduct is an extraordinarily important issue, and I want to thank the witnesses for their candor. There being no further business, the subcommittee stands adjourned.
It's